Testing. Testing. Oh. Okay. Yeah. Okay. Testing. Recording. Testing. Good morning. Good morning. Okay. Okay. Today on the antenuptial contract where couples have a clause providing for no spousal maintenance in the event of divorce. So today we're just going to learn, is that clause enforceable? And then what happens in the event where one of the parties have a financial need and they need to be maintained? So Advocate Goliath will take us through the decided case law and how couples can claim spousal maintenance despite such clause in their antenuptial contract. Advocate Goliath will also do a second talk today, later today, on the types of high court divorce orders that can be varied by the maintenance courts. And we all know that maintenance courts can amend or change maintenance orders where there is a financial need. But did you know that the maintenance courts actually have jurisdiction to amend high court orders? And Advocate Goliath will take us through that whole process, referencing some case laws. And then we also have our very own Ms. Runel Ras. She's going to further assist mothers today with the non-compliance with Rule 43 High Court orders. How can a mother complain with going to the High Court if there is a non-compliance with the High Court Rule 43 order? And she's also just going to take us through and give us a step-by-step process of how to file the complaint on a J470 complaint form and founding affidavits explaining the non-compliance and the arrears amount. And she's going to be quite practical, and you do not want to miss that presentation. And ladies and gentlemen, we also have a very special guest in our midst today, and Ms. Shireen Rahut from the Weinberg Sexual Offences Court. She will explain today how she assisted a sexual offense victim in Northern Ireland to testify in the Weinberg Sexual Offences Court with a visual Section 158 audiovisual links. Ms. Rahut will also explain how she protects her witnesses in sexual offenses matters and how mothers and children can be protected in terms of Section 51A, intermediaries, and Section 51C, audiovisual links, in any other matter than criminal matters, which means can a mother apply to have an intermediary available at the Section 6 maintenance inquiry or the Section 10 maintenance inquiry or even Section 31 criminal prosecution. And yeah, so we look forward to hearing Ms. Rahut explain how mothers can apply in terms of Section 51C of the Criminal and Related Matters or Amendment Act 12 of 2021 to testify with an audiovisual link from anywhere in South Africa. Did you know you could actually do that? In anywhere in South Africa, you can do it from your hospital bed, you can do it in a place of safety, and you can also do it from any other province. And we look forward to hearing Ms. Rahut take us through that step-by-step process. Ladies and gentlemen, as you all know, Ubuntu is part of who we are in this community. And so our speaker, she's also one of the ambassadors and founding members of the community dialogues, Ms. Liesel Kroner, will talk about how the spirit of Ubuntu is displayed not only in this community dialogue, but also through the WhatsApp group that mothers of the Western Cape, actually from all over South Africa, are a part of. And she's just gonna share what this community or the WhatsApp group is doing for mothers, the support that this group is offering, just practical support. How do they support each other during court appearances, providing lift clubs and other initiatives that they are doing as the community in the WhatsApp group. And then we're going to have our very own advocate, Dion Reiters, who will then end the talk with how attorneys, mediators, family law practitioners assist in family courts and maintenance courts. And then I will then conclude today's dialogue by just giving a quick sneak peek on our November dialogue, which will be focusing on the 16 Days of Activism program. And then obviously, I will also just quickly chat about the 9th of December, which is, believe it or not, our last dialogue for 2023. And just a quick, just some house rules, ladies and gentlemen. Sorry, just some house rules. We do have parking all around this building in Bayton Park Street, Pepper Street, Van Leeuwen Street, as well as Bridge Street. So if you have not parked your car in the parking spot that's reserved for public prosecutors, you might want to move it. Please chat to one of the ambassadors. We're all wearing the name tags, and someone will assist you. And we'll also do have bathrooms on this floor. Just ask one of our ambassadors, and we'll be happy to assist you. And we do have some refreshments in the foyer for our in-person delegates. So please do enjoy our community dialogue hospitality. Just to give you a bit of background on who we are as the NPA SOCA community dialogue. So this dialogue was birthed out of pain, actually, because as you know, most mothers in this nation are suffering in the hands of the justice system in South Africa. We have been wounded by the justice system in this country. Most of the mothers, 9 out of 10, we've experienced pain. So this movement was birthed because mothers could not wait anymore for one day when things change in the justice system. And they decided to take matters into their hands and approach Advocate Dion Reiters, and they said, empower us, educate us, teach us, how can we go to courts and fight for our children? We need the knowledge. Is there room for capacity building? And that's how this movement was birthed. So it's a community initiative. Really, it's men and women who are passionate about justice, but also it's men and women who are willing to rise up and say, I'm not going to wait for one day when things change in this nation or in the justice system of this nation, but I'm going to bring the knowledge, the skills, the resources that I have today to join forces with this community to start to see the change that we want to see in the justice system. So it's people like me and you, mothers like me and you, legal practitioners, mediators, social workers, any member of the public, fathers, mothers, everyone is welcome in this community. Everyone has a voice in this community. Everyone's story matters in this community. This community is about rising up together, joining forces, and acknowledging that the current system is not really working. So what can we do to start to create some solutions or change that we want to see in the future for the sake of our children. So we're going to start the program today with Advocate Dion Reuters. As some of you have seen online, the community dialogues or the members of the community dialogues and some of our speakers, they've been traveling, they've been to Gauteng, to Northwest and Eastern Cape, Savungama, Sihlaba Ukhwelo, and we've been Sihlaba Ukhwelo for the whole year. And it's so great to know that people from other provinces are saying yes to that call. We released a call from this platform to say, Western Cape, we are doing this. Eastern Cape, where are you? Northern Cape, where are you? Gauteng, where are you? Northwest, where are you? So it's great and it's very encouraging to see that Sahlaba Ukhwelo and some of these provinces are answering that call. So ladies and gentlemen, I would like to welcome Advocate Dion Reuters so that he can just start our program today by just giving us a little bit of feedback on those trips. Ladies and gentlemen, let's give a warm hand of applause to Advocate Dion Reuters.
Thank you, Bongi, and good morning to our online viewers. To start off, I need to say a warm welcome to all our in-person attendees. Our own advocate, John Goliath, is here, and he is ready to do 2 presentations today. So I am quite honored to have a legal eagle better than myself to assist you with the legal intricacies of our law. So Advocate Goliath, welcome, and thank you for offering your time to be here this morning and to assist us with the legal minefields out there, and just to make it a little bit easier for our attendees over here in person as well as the online viewers. And then I also need to say a warm welcome to my colleague, Ms. Shaheen Harwood, an experienced and seasoned sexual offences prosecutor in the Wynberg Sexual Offences Courts. And she's going to somehow highlight some of the work she's been doing and show to us how even people that is in a place of safety or at a destination overseas will be able to still be able to communicate and bring their testimony to a court of law. And then I also have a warm welcome to our own Ashraf, that is all the way from Vredendal to be over here. Ashraf Arendse is a forensic social worker assigned to the Vredendal FCS. And instead of just sitting at home and watching it online, Mr. Arendse decided to travel 400 kilometers all the way from Vredendal to be in Cape Town and to be part of the vibrance of our meetings over here. So, Mr. Arendse, welcome. We'll make sure that there's time for questions today for you. Otherwise, Mr. Arendse might boycott a few of our sessions again because he didn't get an opportunity to answer or to ask some of the more important questions that he wanted to ask. And welcome everyone else that is over here today. I just need to give a brief background of what was happening so far for this month in the maintenance field in South Africa. We were invited, or it was a conference in Gauteng that was held at Valverde guest house or hotel or spa, and that was hosted by the Social Justice Network, and it was done in Gauteng. And to my surprise, I found out that we have people that have been watching for 2 years online from the time that the NPA community dialogue started. There were people that were watching online. Annette Anderson, I need to say a very warm welcome. I know you are online watching and have been watching all along. and she also do her background work as far as who present what they were saying. She knows more about Cassie Carstens than what I know about Cassie Carstens. So, Miss Annette Anderson, thank you so much for all your interest in the community dialogues, and I'm really, really honored to have met you and to have spent time with you and your beautiful daughter Geraldine Anderson, as well as Eugene Kun, and their beautiful daughter, to have some time with them. And Catherine, you are doing very well in high jump, long jump, and all the things that I saw of you. So thank you so much for being part of it. And this is what the community dialogue is. It's a family, and all of us come together, and it transcends boundaries of provincial boundaries. And we never knew that there are a Nate Anderson that is watching online and every month following and can give more information about Bongi and when she started, and everyone else is watching you out there, Bongi. So don't think it is just that you are over here, but people appreciate what you are doing for the community dialogue. And I've seen and I've heard it firsthand from our participants at the Social Justice Network conference on mediation in Gauteng. Wonderful conference that we had up north with wonderful speakers. And I really hope that some of the footage will be shown online. There were amazing speakers, Pastor John and Mr. Barent, what's his surname? And Lagrange and all the other speakers that we had online and in person at our conference. Lienke de Jong was there, Professor Lienke de Jong was there, Eugene Opperman was there, Natalie, Lynette, Dr. Lynette who was there, Nat Reiters was there, and everyone, the big fish in the field of maintenance and family law in South Africa. The giant Mervyn van Meulen was there. So it was a stunning conference. People were just imparting their knowledge and know-how of the maintenance system. We also had speakers from Liberty Life that gave us an idea of how you can protect yourself and your family for the day that you're not there. And we had wonderful interaction with some of them, and hopefully maybe in 2024 we can get some of them to come and speak at our dialogue, even if it's online, but to get their involvement in how mothers can make it a little bit better for the communities and for mothers out there. I also want to say, Chaplain Stevens, I'm so sorry that I couldn't get you the online link and that you had to use all your medals in order to get into the venue, but it worked. So at least you're here. I humbly apologize. The link, I should have sent you the new link, but I was so busy last week, I just didn't get time to touch ground in order to do what I had to do over here this morning in order to get everything set up. If it wasn't for Nikki that came and woke me at 5:30 this morning, I still would not have been up and running. But Nikki was at my door 5:30 to say there's a community dialogue and we need to move. So 6 o'clock, she was already over here making sure that the coffee and the water will be boiling and all of it. So thank you so much, Nikki, for all your assistance to us. And I want to tell you that Nikki is 82 years young, but she is always there to serve our community. Nikki, can you please stand so people can see who you are? Nikki, can you stand? That is our own Nikki, and she does have a case in the maintenance courts, but she is so involved, you will swear that she have got a matter somewhere in one of the 57 maintenance courts in the Western Cape, the way she is going on and trying to assist wherever she can. And that's what Ubuntu is all about. Everyone giving a little bit of themselves even if it is that you wake up 5:30 in the morning to make sure that we get all the techno stuff sorted out, and then that is what it's all about. We also have our own Faldila de Vries. Faldila, can you please stand? Another young lady that is part of our movement and always contributing, whether it's a pair of shoes every month that she used to contribute via the SPA network, then that is what she will do, but always giving something of herself to the community dialogue movement. And then we also have Tracy. I know you don't want me to say it, Tracy Harris, as well as Maya and Maya's boyfriend. Sorry, I forgot your name, but always there to assist us. But this is how the community grows. We start off with one, and then the other one comes, and the other one brings the boyfriend, and that's how we're just getting bigger and bigger. But yeah, that's what it's all about, is family. And if we are the family nucleus, then that's where we start to somehow make it a little bit better and learn and find out what is your problem, how can I help you? And that is what the community dialogue has all been about. So we were up in Gauteng for the Social Justice Network. After the Social Justice Network on mediations, uh, my wife and I moved to East London, where we were at Fort Hare University, where there was a colloquium on maintenance that was spearheaded by the University of Fort Hare, and Dr. Nokanya Ndlovu. I know she's also online listening this morning, and say and Untandile, colleague, and we had a maintenance dialogue, maintenance workshop, maintenance colloquium from Tuesday in East London at the Mpekuni resort. Stunning place. I was having a ball of a time while working, still enjoying and walking on the beach with your wife while you're supposed to work, is there's nothing better than that. And also participating with her in the conference was stunning, where people shared on day one their vulnerability and how the maintenance system is not working for them, and what can we do to make it better. There was a stunning gentleman over there by the name of Mr. Andrew Witboy. He's the Director Legal Services in the Eastern Cape. And he came all the way from his London to address the participants, the delegates at the workshop. And he came and said what the Department of Justice is planning to do as far as making it better for maintenance. And he was quite honest, and I never expected him to be so honest, but giving the feedback as far as where the Eastern Cape maintenance systems are. Then we had another a person, a colleague of mine, Mr. Advocate Roland Kwani, who is a senior maintenance prosecutor with another advocate, Advocate Nolita Modiba, a colleague of ours in the Eastern Cape, that gave feedback as far as why women are hesitant or not wanting to then come forth and say that I've got a maintenance claim and just abandon the maintenance claim. And why are our women psychologically doing that in order to protect themselves and their sanity? And what the NPA would like to encourage the participants to somehow get involved. We also had another person, Akona, I know you are online.
She's not watching the airplanes leave.
She is a traffic controller in East London. But in her free time, she goes to the maintenance courts and help everyone else, just like Liesel Khan here and Arnell Ross over here. We have our own Liesel and Arnell in the Eastern Cape, and her name is Akona. And she's an air traffic controller, and if she's not controlling the planes, then she controls how the maintenance course is working and not working, then she will sort it out. Always looking to sort the things out. So Akona, thank you so much for what you are doing and still wanting to do. There was a grandmother that told us her story of how for 14 years she's been struggling to get maintenance. maintenance. And eventually she got maintenance, but she only got an order for 500 rand. And but she was never happy with the order. But now she sits in this predicament that she can't appeal the order. Section 25 says you can't appeal a consent order, but she was compelled into agreeing to an order that she didn't want to agree on. So she sits with this predicament, and our corner decided to take that upon herself, and she's going to help Mama to get a case sorted out. We had researchers from the University of Fort Hare that also came and introduced their research papers on maintenance. So there are a tertiary level, a lot of interest in somehow doing research in the field of maintenance, and how we can make it better for women out there. So Dr. Ndlovu, we're looking forward to you and your team's papers, and to show what is happening in South Africa now. I would really like that to be then introduced to the Law Commission and to the Justice Portfolio Committee when the Maintenance Amendment Bill goes before Parliament in the Justice Portfolio Committee. Professor Linky de Jong was always over there and ensuring that she then gave her presentation on maintenance, and the essay Law Commission paper 157 on maintenance. She presented what the finding of the Law Commission is and what is going to happen when this paper goes to Parliament. So stunning work that is happening at the Law Commission, that is spearheaded by our own Professor Linky de Jong. Then the usual experts that couldn't make it offered their time online. Laurie Guyvenstein then managed to log online and then present his paper on maintenance and the credit bureau system, and how the credit bureau system can somehow be used in order to hold respondents accountable. Stunning paper that he delivered. And if any of you would like to get a copy of it, please send me an email, and I will make it available to those that would like to view. I'll need to ask Laurie's permission, but I know he loves sharing his information, so I don't think we'll have any problem in sharing his thoughts on it, because it is encapsulated in paper 157. The whole paper 157 is actually that if they want to give a new title to it, they can call it Laurie Guyvenstein's thesis on maintenance, because everything in that paper is always commented on by Laurie Guyvenstein and his wife Anneke Guyvenstein. Luckily, Ms. Guyvenstein, Anneke Guyvenstein, was in person there, and she did a presentation on the maintenance app, the parenting app that they developed, and how it can assist women out there in order to make it better. Day two was more finding ways or solutions to what we are having problems with in the maintenance system, where my wife Natalie presented her paper on the possible solutions in making the maintenance system better, looking at paper 157, looking at the position of adult children, and the work that she have been doing at the Weinberg courts pertaining to mediations, and how mediations can somehow spearhead a way of somehow getting a quicker solution to maintenance agreements than what is currently happening in our maintenance system. I also presented my presentation. Mine was on the community dialogues and what we are doing at the community level. And there are some people that want to now immigrate from the Eastern Cape to the Western Cape. One of our moms that was there, the Gogo that is having a problem with her case in his London court, said she thinks she must rather just move to the Western Cape, because it seems as everything is working perfectly over there. Then we had Miss Jacqueline Warren and her team, Martina and Tammy, also from the Anova Park First Community Center, where they say how they help women in the Nova Park communities to somehow get access to domestic violence orders, how to assist with maintenance orders, and all of the work that they are doing in the. There were some community members that were part of this London group that they never knew that NGOs are so involved, and maybe they should also move to the Western Cape. So if there's all of a sudden more migration from Eastern Cape to the Western Cape, it was spearheaded by the Western Cape delegation that attended the Eastern Cape for the colloquium on maintenance. So that is what was happening up north, but it was vibrant to see how many people are involved in their own pockets of excellence. There was a lady from SOCA that said something very important. We are working in silos and we're not finding one another. And we need to put all of these energies together in order to make it better for our Yisa. I really enjoyed what you said and how she brought things from SASA to the table and how they work together. Then we also had the UN
UNICEF.
UNICEF, yeah, Caroline from UNICEF there, and she came all the way from Johannesburg to come and spend time with us and just give UNICEF's view and their inputs as far as how they are willing to assist and contribute to.
Pillar 7 that they're creating with NSP.
Yes, and the Pillar 7 that they would like to create on the NSP and make it more accessible for children to get access to maintenance and other social assistance in Pillar 7 of the NSP that will be done shortly. So thank you so much, Caroline. What's her name? Caroline, and Dr. Ndlovu, Akona, and all the other beautiful people that were in the Eastern Cape and East London. Thank you so much for all your contributions. I've got some of the slides and things that I can share with those of you that would like to get it. I've got Mr. Woodboy, the Director Legal Services. I've got his presentation. So if any of you want any of the presentations, info at communitydialogue.co.za, and I will then make all of that available to you. But a stunning conference that was up north, as well as Eastern Cape is the west. Can't be east, must be west. All right, but geography. I studied law. I didn't study geography. Wherever the Eastern Cape is, that's where we were. And thank you so much for all of those people on that side. I will leave the 16 days of activism for our MC for her to then give some feedback as far as what we are planning for November in the community dialogues. Also look out for the Darabas of the 1st of November. There is going to be a beautiful article on the rights of adult dependent children that was written by Natalie Reiters. So please read the follow-up article pertaining to the DWT case and what happened in George and the consequences of DWT versus MT, and how that will change the landscape as far as adult dependent children accessing maintenance in the maintenance court. It is due for publications on the 1st of November. Those of you that can't find it, just send an email to info at maintenance dialogue community. What's the email address? Info at? Hello. Hello at communitydialogue.co.za. So there you will be able to get it then. Those that are part of our WhatsApp groups, we will make sure that the 1st of November by 12 o'clock, it will be in your inbox where you'll be able to read that specific article. I know that according to the program, Advocate Goliath will go first, but we will ask Arnell to go first because she's got another commitment that she needs to go to. So I will hand over to my esteemed colleague Arnell Russ that will do a presentation on Rule 43, because there is this nuance or this perception that if you have a Rule 43 order in the High Court, it can only be amended in the High Court. That's not true. The Maintenance Court has got extraterritorial jurisdiction to amend the High Court Rule 43 or the Rule 58 Regional Court order. But over to Ms. Arnel Ras that will guide us to Rule 43. Thank you.
Morning, everyone. I'm just checking if everyone can hear me at the back. All right, thank you so much. Thank you to Advocate Reuters for the feedback session. I have noticed that we were out of time for quite some time, so thank you so much. And it's encouraging to hear all other participants, reaching out, coming together to try and solve this problem or try and do whatever they can. And it's encouraging to hear that, university students are embracing this as well, because this is where we want it. I mean, this is ground level. We want new legal practitioners to be up and running with maintenance issues. So, yeah, it's very encouraging to hear. And thank you so much for traveling there. Thank you so much for everyone here this morning. We understand it's the end of the month and it's a Saturday, and thank you so much for your time. Thank you so much for the speakers and all the professionals. And then for people like me, the layperson, thank you so much. And then special thanks to the ambassadors. Thank you so much for doing all the back work, the work in the back office. We really appreciate it, because it's the whole month that things needs to be in place. So we really, really appreciate your time and commitment. Thank you so much. And then to Mr. Arendse, in particular, thank you for driving all the way from Vredendal. I know where that is. And it's quite some drive. It's a beautiful drive though, but it's quite some drive. Thank you so much. Maar as jy net 'n bietjie terughou met die vrae van nou, asseblief. Because I'm going to be under pressure here if you start with the questions now. No, I'm just kidding. So what I'm covering this morning, as Advocate Reuters correctly stated, is regarding does a maintenance court have jurisdiction regarding regulation or rule, 43 and 58 High Court and Regional Court orders. And I'll go through what that means as well. What is a Rule 43 and what is a Rule 58 order? Unfortunately, we need to go to the basics first, and then I'm going to go to the slides, but I'll also be giving my input as well. But it's important to understand, everyone, what do they mean with them? What's the basic? What's the definition of a maintenance order? So we will look at section 31, offenses relating to maintenance orders. Subsection 1, it says, subject to the provisions of subsection 2, any person who fails to make any particular payment in accordance with a maintenance order shall be guilty of an offense and liable on conviction to a fine or to imprisonment or a period not exceeding 3 years, or to such imprisonment without the option of a fine. So what does a maintenance order mean? It means any order for the payment, including the periodical payment of sums of money towards the maintenance of any person. And the next part is very important, because I will get back to the next part especially. It says by any court in the Republic. So I'm going to stand still later, but please bear in mind this is very important. I remember Advocate Reuters wrote an article in relation to this in the Deribus. I'm not sure, I think it was April this year. Please go online and have a look at the article, because we do find that even though it's in our act that any court can make a maintenance order, we find that this is not happening. And even a lot of those even in a children's court, where maintenance forms part of the parenting plan, you don't see that happening. You see some magistrates, they sign off on the parenting plan, but in section 3 or 33, sorry, it's left open. So the mother is in a children's court already. So that takes time, that's money. She needs to travel there. She needs to possibly take time off work. Now she gets to the children's court. I think everyone knows what the queues look like. Now you sit there for hours. Hopefully you get assisted on day one. Now, hopefully the parenting plan gets made a court order. But now she must hear, or it can be a gentleman as well, but the applicant must hear, oh no, sorry, we're not going to deal with maintenance today. You need to go back to a maintenance court. Why should said applicant go back to another court where they are in a court already? So I will be dealing with that a bit more in detail a bit later in the presentation. So I'm just going to repeat that. By any court in the Republic, and includes, except for the purpose of section 31, any sentence suspended on condition that convicted person make payments of sums of money towards the maintenance of any other person. So any amount, including the High Court Rule 43, and I'll get to that now, or a Regional Court Rule 58 order that ordered the payment of sums of money. So, a Rule 43 High Court order, a Rule 58 Regional Court order, a maintenance order made in a maintenance court, and a Section 33 parenting plan with a maintenance clause. Where there were no non-compliance, you can persuade a civil court order for attachments of assets, emoluments, and pension funds, or request a Section 31 criminal prosecution of the defaulter. And I want to stand still here as well. You, as the applicant, are able to do both. I've heard of some occasions that the mothers will tell me, no, but they were informed they can only do one. They can only either attach assets or, try and prosecute Section 31. That is untrue. Nowhere in the Act does it state you need to choose. So if it doesn't state in the Act that you need to choose, you are the maintenance officer to do both. If I can quickly go, and I'm, like I said, layperson, we have very important and professional people in the room who can assist me better. But a Rule 43 is an interim maintenance order made in High Court. It's in a case where parties are in the process of a divorce and either party has got obviously maintenance needs, either for herself, himself, or the children, or both. And they apply to court for an interim maintenance order until the divorce are settled. Same would be for the Rule 58 in a regional court. It's exactly the same procedure. It's just obviously a lower court than the High Court. And what Advocate Reuters said, in his presentation earlier, is so true. A lot of women, so they approach High Court, or say the respondent or the applicant, in the divorce case, approached High Court. Now it puts a lot of pressure to the other spouse. Now obviously now it's a High Court case. Now that defendant thinks they need to go back to High Court, which is extremely expensive. I mean, the fees, you need an attorney, you would need an advocate. All of them, they need deposits. There must be a transcript of the record. It is thousands of rands. Whereas we want to educate women and mothers and even fathers, because there's instances where the applicant it's a male, that it's not, you don't need to go back to a High Court. There's a non-compliance to a maintenance order. You can go back to a maintenance court, which you can approach for free. So, Section 16.2 of the Maintenance Act, 99 of 1998 provides, and here I want to stand still, any court, in section 2A, it says any court that has at any time before or after the commencement of this act made a maintenance order or under subsection 1AI or BUI that makes such a maintenance order, or South African courts, like the divorce courts, issue interim financial relief to vulnerable parties during divorce proceedings in a Rule 43 High Court divorce matters, and as I said, Rule 58 in the regional divorce matters. If we stand still at the domestic violence 116 of 1998, it also provides emergency monetary relief in section 7.4, and I'm just going to quickly read that as well. It says the domestic violence court may order the respondent to pay emergency monetary relief, having regard to the financial needs and resources of the complainant and the respondent, and such order has the effect of civil judgment of a magistrate's court. The Children's Act 38 of 2005 provides for maintenance in section 33.3 in the parenting plan. And the section 161 of the Act is applicable here. So it refers to parenting plans and provide for maintenance in a section 33.3, while foster parents, and this is very important, I wasn't aware of this as well, foster parents taking care of a foster child can also apply for financial relief in a section 161 contribution order. This is also very important because our country, if I say unfortunate, but this is unfortunate circumstances, but a lot of the communities, you see that other people are taking care of our children. And if I say our children, it is our children. Any child in this country, it's our children. And there's people looking after children that they are not even related, and which I take my hats off to. Section 27.6 of this is also very interesting, of the Older Persons Act 13 of 2006. And I'm not too sure Advocate Goliath needs to assist me. So I think Older Persons Act for a male, it is older than 65, and a female is older than 60. Am I correct in saying that? Ages. Yeah, I'm just checking that, so sorry. It says an order that the alleged offender will be responsible for the maintenance of his or her family during the period contemplated in paragraph A. Or, let me just go back here. Okay, so I'm not sure if someone, okay, I'm sorry about this. I apologize for the slides, but let me carry on with the presentation. So the maintenance order means any order for the payment, including a periodical payment of sums of money towards the maintenance of any person issued by any court in the Republic, and includes, except for the purposes of Section 31, any sentence suspended on condition that a convicted person may make payments of sums of money, towards the maintenance of any other person. So it is not just maintenance courts that can make maintenance orders. Any court can make a maintenance order. That includes a divorce court, a children's court, a domestic violence court, family courts. It includes the Rule 43 High Court divorce orders. In the children's court, as I said before, Section 33.3 of the parenting plan. In the domestic violence court, the Section 7.4 for emergency monetary relief. The family court, as I said before, the Older Persons Act, Section 27.6c. So the question we need to ask is, why are these courts not making these orders? If it's in the Act, and if the NSP, I'm not sure if everyone is aware, but it's an initiative by our government, and it's got a few pillars. Six, sorry, at the moment. And as we heard before, I think UNICEF that wants to add another pillar. So pillar 5 deals with economic empowerment. So my question is, if Pillar 5 deals with economic empowerment, why are the courts not making these maintenance orders? Why are you not empowering your people? But it looks very good, when there's lots of conferences and everything is in color, it's beautiful, it's bright. But when it gets to the ground level, where people are not going to feed their own children, where are you then? If you're saying you want to empower people by economic empowerment, why are these courts not making these maintenance orders? Can a Rule 43 order be persuaded in the maintenance courts? Yes. Rule 43 High Court order is like any other maintenance order. Thank you. That can be persuaded in the maintenance court in civil attachments. That's your Section 26 and Section 30 attachments. Or in Section 31, prosecutions for non-compliance of the Rule 43 order. The Rule 58 region court orders, the interim maintenance as I discussed, is like any other court order and can be persuaded by the maintenance court in civil attachments as above. Same thing, Section 26 to 30 attachments, or in a Section 31 prosecution, criminal, for non-compliance of the Rule 43 order, or the 58 thing. So any order can be persuaded in maintenance courts, because maintenance courts, and as Advocate Reiters correctly stated earlier, have extraterritorial jurisdiction to hear these types of maintenance orders. That's why they're there. It's a special court. It's called a maintenance court. That's why they are there. There's a specific court case, a Western Cape High Court case, that found maintenance courts have jurisdiction to hear civil attachments orders. And it's the case of Magiwe versus Zozo. I hope I pronounced it correctly. And then the second one was, a lot of us, if you don't have knowledge about these acts, you're unaware, and most of us, and myself included, you think, okay, you hear like a magistrate court or regional court, they only have jurisdiction to, I think it's 400,000, if I'm correct. But a maintenance court have extraterritorial powers. And even if it's more, like it can be, even if it's millions of rands, they have the power to make that a court order. There is a specific case law regarding this. It's Soller versus Magistrate Weinberg. That is the case law that you can go and Google, and you will find that the maintenance courts may grant orders that run into millions of rands. So, which form do I need to use? Because this is also important. You get to the maintenance court, most of us, we don't know which forms to complete, what to complete on the forms. We have never done an affidavit. And I want to urge everyone, please have a look at the forms. If you can share with people around you that is struggling with maintenance, the founding affidavits can be found on the website, and I've said it before and I'm going to say this again, www.childmaintenance.org.za. There's various founding affidavits. It's almost like a pro forma affidavit. And all you do, you just change your details to suit the affidavit. But there is founding affidavits on the website. So you complete, so if there's defaulting action, if the other party did not comply with the maintenance court order, you complete a J47, that is the complaint form. This is for the civil attachment. And you complete the J306 application form. You need to complete both forms. The court clerk can call the respondent and inquire why he or she is not complying with the maintenance order. They can also warn the respondent that immediate garnishing order in terms of Section 28(1)(d), the Maintenance Amendment Act can be given against them. There can be an immediate garnishing order granted. Defaulting action, the civil attachment, as I just discussed, if complaint comes and complains about the defaults, you need to complete the J47 complaint form once again and a J306 complaint form or application form, excuse me. Also, once again, both forms needs to be completed. Clerks can call the respondent while the applicant is busy completing the forms and ask him why he is not complying, he or she is not complying with the maintenance order. I'd just like to refer to the section 28(1) in the Maintenance Act, which says, provided that nothing precludes the court from making an order in terms of this subsection, if it is of the opinion that any further postponement of the inquiry in order to obtain the evidence of the person referred to in paragraph D will give rise to an unreasonable delay in the finalization of the inquiry to the detriment of the person or persons to be maintained. So when you complete these forms, please submit a founding affidavit as well, and make sure, enlighten the court that there will be detriment. The person or persons or your child or yourself, they will be, if they are not being maintained, they will, if there's an unreasonable delay, it obviously will have a huge effect on said person or persons. So the defaulting respondents can also be prosecuted by the NPA. You need to send a letter to the NPA requesting the prosecution. You only have to prove that the respondent have means. And this is also where I'd like to stand still. Apologies. Means is not just money or employment. Means, and I'm going to go to my slides now, but means can be anything like shares, Bitcoin, cryptocurrency. It can be livestock, as mentioned there. So it can be bonuses. It's not just your salary that you receive from your employer. So maintenance order means any order for payment in kind, either by way of supplying specified goods, which may be livestock or providing a service or services, and or 16(1)(a), any court making an order for payment in kind as defined in section 1 must make an order in the alternative for payment of sum of money equivalent to the estimated value of the order of payment of kind. You know, I hear the some story as well, but said person can't afford whatever maintenance order was made. Then take food to your children. If you say you can't afford the 2,000, you can't afford a garnishing order, and you can't do this, your child, it's your responsibility, both parents, but it is your responsibility. Then take food to the mother of the child. It is your child. They have a right to be fed and lead a healthy life. It's not just food. It's a right to education as well. It's a right to, so I'm not going to go into the details in the Children's Act, but every child has certain rights, and you as a parent, you are obliged. It was your choice to become a parent. So if you can't pay whatever, take food. If you work for a factory so say for instance, food lovers market. Say for instance you work there, take vegetables, take fruits, take whatever you can, but contribute. And that's what they're referring here to as well. The minute the term misconduct is used, so that refers to prosecution that can also prosecute a respondent who voluntarily leaves his employment, or they normally threaten the applicant, oh, okay, I'm just going to leave my employment. And some do. And that's the scary part. Like, I don't even understand it. Why would you leave your job? Not just to pay maintenance. You also then don't have a job. I don't understand it. But the point is, it is misconduct if the court, and remember the court, They don't want your emotions and how harsh it sounds, how harsh I might sound now. They want the facts. So please state all of the facts on a founding affidavit. If you have facts and you can prove that said respondent left employment voluntary, that is misconduct.
Yeah.
He or she needs to support his child or her child. Where a respondent voluntarily takes a severance package, he can be prosecuted. And we can attach his UIF benefits in terms of Section 33(1)(b) of the UIF Act. Ms. Liesel Cornelius spoke about this in the previous community dialogue. So for those of you that have missed it, you're welcome to just go onto YouTube and follow that link and have a look at her explaining how, what the process involves. To actually, you can attach his UIF or her UIF as well. Okay, so respond not coming to court for inquiry because they are very busy. Regulation 3, so it says any person who fails to comply with a direction contemplated in sub-regulation 1 shall be guilty of an offence. Oops, sorry. On conviction to imprisonment for a period not exceeding 6 months. Note, on Regulation 3 directive, put in a court number below the room number of the regulation directive. Section 35 of the Maintenance Act specifies offences relating to maintenance inquiries. So it specifically says the following. Any person who willfully interrupts the proceedings at a maintenance inquiry, and I do believe that includes a Section 6 informal inquiry as well. So Section 6 inquiry is the informal inquiry in front of the magistrate, the maintenance officer, and a Section 10 inquiry is the formal inquiry in front of a magistrate. I just need to clarify that as well. So we are talking about both. So the Act states at a maintenance inquiry, which will be both informal or formal, or who willfully hinders or obstructs the maintenance court, the performance of the maintenance court's functions at the inquiry, shall be guilty of an offence and liable on conviction to a fine or imprisonment for a period not exceeding 1 year, or to both fine and such imprisonment. Now, in my mind, and advocate raters need to assist me here, but in my mind, and because I'm a layperson, this is how I understand this section, willfully interrupts, in my mind, speaks to the fact that you don't bring your income, you don't bring your bank statements, because you try to willfully interrupt a maintenance inquiry that needs to take place. You have been warned, the directive told you exactly what to bring to court, and said respondent willfully interrupts. And I'm sure it's also when you lie about your income. So the minute you know the respondent is lying about his means or her means and income, please state that in a founding or a supplementary affidavit and submit to court, and not the day before your court case. Let me stop here. Everyone, we are all extremely busy. We are tired. It's the end of the year. I understand this, but please be vigilant. Please understand that no court will look at an affidavit or anything else one day before it's your court date. Please file said affidavit at least 14 court days in advance. Please make sure the other party has been served as well. Because believe you me, if that other party has not been served, on said date, the court appearance, that will be number one. That will be the issue why they cannot continue. And they've got a right to do so. They can say, but we did not receive it, so we did not have time to scrutinize the documents, and you will get another remandment or postponement. You don't want that. You want to make sure that the date that is set at court is the date that you get the court order as well. Try and do everything in your power to ensure that your side is clean, if I can say that. Make sure your affidavit is submitted way before the court date. Apologies, I stood still there now. If the respondent don't come to court, so Maintenance Act provides for a court that can issue either a J165 or a J50 warrants of arrest. So on a J165, that warrant, if the warrant is not executed within 2 months after receipt, it should be replaced with a J50 warrant of arrest. I just need to check with advocate raters as well. I think the J50, it's a more permanent, am I correct? That's the permanent warrant of arrest. So I'm just mentioning this as well. I think this is also very important information. Another section in our Maintenance Act, that's it, section 16.4, to provide your address. This is also one of those things that said respondent don't report to the court the new address, either the work or the residential address. So you get to court and they didn't pitch up, and then eventually you must hear, oh no, but they don't work or live there at that said address anymore. Yeah. But they had a responsibility to inform the court of a change in address. So failing to provide a new residential address or work address. So we're going to discuss section 16.4. It says, if any person against whom a maintenance order has been made under subsection 1AI or BI changes his or her place of residence or employment during the currency of the maintenance order, he or she shall within 7 days after the day of such change give notice thereof in writing to the maintenance officer of the court where the maintenance order was made. And if the payment in terms of that order is to be made to any person, officer, organization, or institution, then also to the person, officer, organization, or institution to whom the payment is to be made, and shall state fully and clearly where his or her new place of residence or employment is situated. So it's literally an offense if you do not make sure that the court knows your change in address within 7 days. Section 39 provides for the following. This is the offenses relating to notice of change of address. So any person who refuses or fails to give notice of any change of his or her place of residence or employment as required by section 16.4 shall be guilty of an offense and liable on conviction to a fine or to imprisonment for a period not exceeding 1 year. Please note, this is very important. Please note, prosecutors can only add this charge if the respondent was warned during the section 6 inquiry by the maintenance officer, the rights of the parties form. Remember in last month's community dialogue, for those who followed it, if you haven't, I suggest to go onto YouTube and just have a look again at last month's community dialogue. I discussed the paternity form that you must please make sure that's completed and signed the first day that you step into that maintenance officer's office, as well as the rights of the parties form. Because like you can see now, this will be also used, I won't say against you, but that it's a delaying tactic. So you'll do whatever you need to be doing, try and get your, a money or a monument or attachment of debt or whatever the case may be. And then when the prosecutor wants to add it or wants to try and, oh no, sorry, I haven't been read my rights. So it will happen. This will happen as well. So I'm just going to repeat that again. Section 6 inquiry by the maintenance officer. So the maintenance officer, if you sit there at the section 6 inquiry in front of that maintenance officer, and said maintenance officer did not read you the rights of the parties form, please ask them to do so. So if it was not signed or it is not on record that the court warned him that he should inform the court, you won't be able to prosecute in terms of Section 39. Section 27, so now we will go to the warrants of executions. Maintenance staff, and this is a big one as well, should assist applicants to get the J397 warrant of execution executed by the sheriff. You'll find, and it's understandably so, that the applicants do not have money to pay that security fee to the sheriff. It is possible, they don't want to tell you this, but it is possible to ask the court in writing, please assist the security fee, because the court can then, when the sale proceeded and whatever was sold, they can once again get that security fee back. They can deduct that from whatever was sold, a car or whatever the case may be. So obviously a lot of applicants will not have the 5,000 or 10,000 rand security fee, but it is possible for the court to assist mothers or fathers with that. So I'm not going to go through each and every sentence, but it's exactly what I just said. I also want to make note that what I just said regarding they should assist and they can assist actually is in the DOJ's code. It's that code service chapter. And it's the code, the 26 of 2015. There's a code for family courts, and you will find it in there. And it has been distributed before at the community dialogues. And I think it is on the website as well. Yes, you'll find it on www.childmaintenance.org.za. Please have a look at page 37 and 38, paragraph 40.1. Court manager can arrange with sheriff the free service of Section 27. So yeah, please put that in writing. Please make sure that the court pay. You don't want to lose that money because, oh no, sorry, I can't afford the sheriff's fee. Ask for them to apply on your behalf. Prosecution of defaulters. Prosecution of defaulting respondents. The applicant complains that the respondent is not complying with the parenting plan, Section 33.3, of the maintenance clause, or a divorce order, or a Rule 43, or a Rule 58. The clerk must inform the applicant to complete, as I said before, a J470 complaints form. So you need to wait for 10 days. 10 days must lapse before you can apply. You need to complete a J, like I said, 470 and a J306 for the enforcement of the maintenance order. So the clerk will complete the J307 and an affidavit stating the arrears and that more than 10 days has lapsed. That is very important as well. It is not compulsory. This is a very important case. I remember this one. It's not compulsory to give notice to be given, especially if the children will suffer undue detriment and the remand is unreasonable to the detriment of the children and the applicant. There was a court case, and it's actually stated there. It's the case of VWB versus VWD and Discovery and Stand-Up, where the respondent did not comply with the maintenance court order, and maintenance clerk or maintenance officer did what was expected from them, and they took, I think, one of his, it was retirement annuity at Discovery. And afterwards, the respondent went to the High Court to make a huge thing about how can maintenance court take his retirement annuity. But then it was explained to him that the court did not have to give notice. He already did not comply. He or she, okay, in this case it was a gentleman. He already did not comply with a court order. say they do not need to give notice. The Maintenance Amendment Act shall also provide in sections 28(1)(d), provided that nothing precludes the court from making an order in terms of the subsection, if it is of the opinion that any further postponement of the inquiry in order to obtain the evidence of the person referred to in paragraph D will give rise to an unreasonable delay in the finalization of the inquiry to the detriment. So he did not comply with a court order to pay maintenance towards a child. So in my opinion, I think what was important for the court is children will suffer. Said person can still make up for his pension in years to come, but the child or children needs to be fed. And the court will normally need to look at the best interest of the child. So they do not need to give notice. Prosecution of defaulting respondents. The NPA can prosecute the respondent for the Section 31(1) for non-compliance. That's for the Children's Act. A Section 34 for giving false information during inquiry, or for charge of perjury. Because remember, if you are lying to court regarding your means, or you're lying to court in connection with anything regarding a maintenance inquiry, it is the same as, if it's in an affidavit, it's the same, or you're stating it under oath, it's perjury. Section 35 for interrupting the inquiry proceedings or intentionally staying away. 1 year sentence, fine, or both. Section 37, not disclosing bank statements or income. Once again, 1 year sentence, fine, or both. Section 38, not complying with certain notices, like the emolument detachment order, 2 year sentence, a fine, or both. Section 39, not informing maintenance courts of a change of address, which we discussed earlier. 1 year sentence, a fine, or both. And then Section 39A, hinders or obstructs a maintenance investigator. So 2 year sentence, fine, or both. Please note, Section 54(1) of the Criminal Procedures Act, that a prosecutor must decide whether to enroll a maintenance matter by instructing the clerk on a J605 summons or a J50 warrant of arrest, as we just discussed earlier. The prosecutor will give the name and surname, address, and charges to the clerk, and the clerk to complete the J605. So whose duty it is? The clerk of the court and the prosecutor duties. Where the defaulter have been prosecuted for, a J50 warrant of arrest can be issued, and that is the one that is permanent, as Advocate Reuters mentioned. So if it's a person that has default in the past, ask the court to issue a J50 warrant, because that is a permanent warrant of arrest. Once prosecutor decided to enroll the matter, it cannot be sent back to a maintenance officer for a Section 41 conversion. There is case law concerning this, September versus September. No rule in law that a convicted accused cannot be sent to prison. Sure. Yeah, there was a case, State versus Visser. So there is case law regarding that as well. And then there was a case, and I think the lady was even, she was present, the Potgieter case. So the State versus Potgieter, a first offender can be sentenced to custodial, can get a custodial sentence as well. Now, blacklisting, which Advocate Reuters touched on earlier, so I'm just going to quickly run through that as well. Blacklisting of accused, it's called a Section 31(4). There's a Form W that is completed by the prosecutor and submitted to the magistrate to explain consequences of blacklisting. And I just want to quickly stand still here before I carry on. It is on so many occasions that I've heard from mothers that they need to indebt themselves to make sure that their children have food on the table. So there's many instances where mother's credit report looks terrible, or they are being blacklisted for actually trying to put food on the table for their children. So my question is, why is this not being persuaded more? If a if a respondent that does not comply with a maintenance order, why is this? Because I know we've discussed this before. I know it was Mr. Zimmerman that spoke about it as well. There was an attorney that was here a few months ago. But maybe I'm wrong because I don't deal with it every day, but I've never heard of a case where that has actually happened. You see, and that, in my opinion, it speaks to the political will. Because why can mothers be blacklisted? Because they need to put food on the table for children. But the people that does not comply, respondents that does not comply, I have never heard of a respondent, a defaulting respondent who's been blacklisted. I might be wrong, as I said, I don't deal with this every day, but I've never heard about it. And the question we need to ask, and we are allowed to ask this, why not?
Yeah.
Okay, that is me. There you go. Thank you so much for your time. I appreciate it. Thank you.
Okay, thank you so much, Ms. Ronalra. So we're going to take about 10 minutes to do a quick Q&A session. So I would like to encourage our online viewers as well to just send through some questions for Ms. Ronalra. So does anyone have any questions to ask? Yeah,
We made provision for it.
we did, yeah. Anyone going once and twice? Okay. Oh, okay. Yeah, go for it.
Can I ask if you're comfortable? Would you be able to ask it yes at our online?
Okay.
Or you can ask me and then we can relay it here.
Okay.
If you're not comfortable. Okay. Okay, sorry.
I was husband. We have a rule 43. We have a rule 43, and he went. I was applicant to the rule 43, which was an order last year March. He went now to the High Court of the rule 43.6. I'm not so sure on what grounds. Because it really stated in this 250-page affidavit.
Sure.
But we've been waiting now 10 weeks for our judgment because the judge said that she can't give a judgment. So in this week we got a letter back to say that why must like you just mentioned, why does the High Court have jurisdiction if it can be dealt with the regional court? So I'm a bit confused because I thought, well, I wasn't the applicant now, he's not the applicant for the rule 43. But if it was a rule 43 in the High Court, why couldn't it be amended there again?
Sorry, Lauren, do you mean why can't it be taken from High Court back to a regional court?
No,
You mean that?
I don't understand why the judge sent us a letter now agreed to say we must be given the opportunity on Monday just to reply to say why does the court think, the High Court think that, or why does the High Court listen to the matter if there's jurisdiction can be done, or there's just something to do with jurisdiction.
Okay, so I'm just going to quickly try and relay what the question was. A person in the audience has got a Rule 43 High Court order. She was the applicant in the regional High Court order, or asked for a Rule 43. There is an existing Rule 43. And the respondent, it sounds like they submitted 200 and odd page affidavit, which I think tells everyone everything already. Because in my opinion, the court always, especially in Rule 43 orders, they want it succinct. They're not yet for a book. They just want to hear your reasons. And they actually normally they don't take kind to people that actually submit affidavits that with that amount of pages. But that's something, sorry, I'm off the point now. But so your question is,
Maybe I can read it.
okay, that will be great. Sorry about this.
So that just makes more sense. I'll just read the last paragraph. On what basis? Okay. Counsel for the applicant and the respondent each file short written argument dealing with the following issues. I've got the first one. On which basis the High Court has jurisdiction to consider either of the Rule 336 variation applications, especially given that in March 22 order contemplates the parties can apply the regional court of variation and the ruling in SW versus W, especially paragraph 19 to 22. And whether there's any reason that the court should not refer the Rule 336 variations to the regional court.
Okay, so if I understand the question correctly, the High Court now is actually asking both parties to inform the court, the High Court now, why the High Court needs to make a decision where it can be made in another court. Am I understanding that correctly?
So for me, that's almost like a waste of my money. It's
Exactly.
like 60,000 rand to
Sure,
defend myself.
sure.
Yeah, you see, and that is, I think that is exactly what I discussed in my presentation today. It's so sad to see parties running back to High Court because normally they know the other party do not have the funds to defend those actions in a High Court. So, like I said before, the maintenance court even had the jurisdiction to hear this matter, in my opinion. But I would ask Advocate Reuters to give more context to that because I am not too sure. I might say something. Okay. Okay. So for the online listeners and for Lauren, Advocate Goliath will be addressing that specific question. So I'm sorry, I don't have the correct answer for you. But as I discussed in my presentation, that is exactly why we say the maintenance court has got extraterritorial powers. They have jurisdiction to hear orders that has been made. So my question quickly, did he already not comply with the order? Is he defaulting? Has he been defaulting on the order?
In some parts of the rule,
Oh, you see. Okay, so you see, that's my point. Remember, we had a discussion. It should be the said person should be defaulting on the order.
so in some parts it has defaulted, and that's why I'm not too sure why he brought in the application already to try and reduce the maintenance when he's already defaulting.
Sure.
And that's a valid point. And that's a valid point that should be in an affidavit. Because I see a lot of parties are doing this. They are drowning. It's actually like plundering the funds of the applicant that already, that's why the applicant applied for Rule 43 to get interim maintenance to support herself and the kids. And now the other party is going back to court knowingly that the party, the applicant, cannot afford those fees. It's actually to try and make sure that the other party is throwing in the proverbial towel, irrespective of the merits of the case. The other party, the applicant's case can be actually a very good case, but it's for you to throw in the towel. Sorry, with respect, in my opinion. That's how I see it. But Advocate Goliath will be discussing your question. And to the online viewers, he will be discussing it in detail. I'm just a bit out of my depth here, so sorry, I don't know the intricacies of High Court and the law. But thank you so much for your question. I really appreciate it. Is there any other questions?
Maybe Jonathan can answer.
I'm just thinking about, Rule 46 is a variation. The only reason that I can find right now for the High Court to get kind of decision is because of the backlog in terms of opposing matters right now.
Yes.
For opposed wars right now, you're going to get it back in November 2024.
Oh my word.
So all the opposed matters, are almost being transferred right now to your regional court because they can quicker.
Yes.
That's the only reason I can see right now that it makes a little bit sense to me.
Sure.
Because, the Rule 43 is give you interim relief. So it's a quicker way, it's supposed to be a quicker way.
Exactly.
But now if the court asks you why we must entertain you, it doesn't make sense to me, to be quite honest with you. It just doesn't make sense to me. So for me, the only reasons might be that based on the role right now, they might say, okay, the regional court is going to entertain it quicker, or try to almost like divert your cases to your specific courts right now. So, for example, come with really urgent letters to the High Court. But if you can entertain in a maintenance court, go to the maintenance court.
Makes sense.
That's the only thing I can see right now. Because it doesn't make sense that the High Court said, why must we entertain?
Exactly.
Right.
And I also saw, just an interesting point, I also saw yesterday, the High Court in Gauteng, the Deputy Judge Sutherland, there's a directive issue that there is cases, if it's obviously not urgent, there's cases on the roll now for 2025, and they are giving dates for 2026 already. So there's even pro bono judges sitting in on these matters to try and get the case now down. But it looks like it's just not happening. So this is a very grave concern.
Yeah.
To hear that there's dates that's being allocated for 2026, and we are in 2023, obviously. So 3 years, I mean, that is, and like you said, thank you for that. Thank you for adding that. Why can she not just go back to the maintenance court? And you see what I find as well, and with respect to legal practitioners, the minute an applicant goes back, because relief is not found at the place where she originally sought relief from. Now, when she wants to go back to another court, say for instance the maintenance court, oh no, sorry, it's Lisbon Dens. Sorry, you can't have a matter that's already in one court for another court.
Yeah.
And that is also something that needs to be addressed, because on the scale of justice, what weighs more? A child without food?
Yeah.
Or a person that, so there can be nothing more important, in my opinion, than a child or a mother or a father even, but an applicant in dire need, and what they are, there's no two ways about it. They are allowed. That's a right. There's basic rights that we all have. What weighs more? Definitely the needs, and especially of the children. That's what the Constitution states as well. You should always look at the best interest of the children. Whatever is going on here, with respect, how is this in the best interest of the child or children? So, but thank you so much for adding that. I really appreciate your feedback. Thank you, John.
Yeah.
Thank you.
Thank you so much.
Thank you so much, everyone. Enjoy your day. Thank you.
Thank you so much, Ms. Ronaras. But I just want to echo what you just said, because I think sometimes we get caught in this battle. In the midst of this, there are children in this country who need provision today. What is it going to take, ladies and gentlemen? There are children who need basic needs covered today. To those in power and authority in this country, as a mother, there are children in this nation who need provision for basic needs today. While we are caught up in, oh, this one must do this, oh, it's not within my jurisdiction, there are children today in this nation, our children. Last week, I did not have money to take my child to school. Last week. Where am I supposed to go? Because the system has failed me. South Africa, we can do better than this. We are already in debt. Where to from here, ladies and gentlemen? Where do we go from here? The system needs to change. Where to from here? Where do mothers like me go when I don't have money to take my son to school? Where do I go? Where do I go when I don't know what to feed my son for dinner? Because the system has failed me. Where do I go? So to those who have the power and the authority in this country to bring about change, I stand here as a mother, I'm asking, where should I go when I cannot feed my child, when I cannot take my child to school? On that note, I would like to welcome Advocate Goliath, who is going to address us today about anti-social contracts and spousal maintenance. Ladies and gentlemen, let's give a warm hand of applause for Advocate Goliath, please.
Good morning.
Good morning.
To the room at large and to our online viewers. It's always a privilege forming part of dialogues in order to impart knowledge with regards to matters that affect us personally on a day-to-day basis. So I was tasked with what did I say, the mandate in order to come and have a discussion on anti-nuptial contracts as well as spousal maintenance. So I will be as concise as possible and not drag time. The question is, can an anti-nuptial clause excluding spousal maintenance be enforced in maintenance applications for spousal maintenance? Spouses, when concluding anti-nuptial contracts, or parties rather, are generally free to include any provision in an anti-nuptial contract. However, the provision may not be contra bones mores, which basically means goes against the good morals or against public policy when it comes to contracting between parties. So when a clause or provision included in an anti-nuptial contract, one has to consider whether such a clause will be going against public policy, whether it will go against the good morals of the public, or furthermore, whether it will be prohibited by any law or purport to take power away from the courts. So if you have such a clause, for example, where spousal maintenance is excluded post-divorce between the parties, usually our courts have favored that such clauses will be null and void. This was confirmed in a case which was heard in the Supreme Court of Appeal, a 2018 judgment. The citation is SC versus CT. This was a judgment that handed down in the Western Cape Division that was then taken upon appeal before the Supreme Court of Appeal, where the court had to consider whether a waiver of right to claim maintenance upon dissolution of a marriage in an anti-nuptial agreement, whether that is invalid and unenforceable. The Honorable Court in that instance agreed that a clause in a anti-nuptial contract stating that spousal maintenance should not be considered or enforced upon the dissolution of the parties upon divorce is null and void. In Coming to that determination, the court looked at the following clause, which was stated in the antenuptial contract, which read as follows. The intended wife accepts the donation in clause 6 and 8 on conditions stipulated therein, and in consideration thereof waives any respect or future right whatever that she has or may have to claim maintenance for herself on dissolution of the intended marriage in whatever manner and for whatever reason, and regardless of the conduct of the parties. Now, what the court considered with interpreting that clause of the antenuptial contract was the following. Firstly, the wife, upon divorce, challenged the validity and enforceability of the waiver clause on these four grounds: that the clause is per se a matter of legal principle inconsistent with public policy, that the effect of the clause is unreasonable, unfair, unjust, and thus against public policy, that the enforcement of that clause would be unreasonable and against public policy, and that the court has an overriding discretion to award maintenance, notwithstanding the waiver provisions. The High Court, the Western Cape, in the Western Cape Division, when hearing this matter, decided that they upheld all those arguments that was made by the lady disputing this clause excluding spousal maintenance post-divorce, and they thus held that that clause was invalid and therefore unenforceable. In the Supreme Court of Appeal judgment of SC versus CT, the Honorable Court concurred with the Court of First Instance. That then does confirm that at this current stage, such clauses, our courts would be, worth taking into account the circumstances and the merits of each individual case, would most probably go with the option of not enforcing such clauses, especially taking into account the economic disparities between parties upon divorce between men and women. The court needs to take all factors into account when making such a determination. Now, Judge or Acting Justice at the Majid in this ST versus CT matter made the following remark, stated that in his view, there is a stark difference between waiver upon divorce of the right of a spouse to seek variation of a maintenance order, as envisaged in terms of Section 8, subsection 1 of the Divorce Act, and a prenuptial waiver of maintenance. The main compelling difference is that at the time of divorce, both spouses have full knowledge of their respective financial means and needs. That is not the case before the parties have married. Furthermore, Section 7, subsection 2 was enacted to provide a statutory right to a spouse to obtain a maintenance order upon divorce. And then furthermore, public policy therefore establishes a statutory right to maintenance upon divorce, and such a right cannot be waived prenuptially. It would offend legal policy and hence public policy. So on that basis, the argument stands that the court still has the power in order to decide whether or not maintenance should be awarded to a spouse upon divorce. Now, with regards to the question posed by one of the our participants here today, I have to agree with my learned colleague. With the rule 43, if I'm correct, from the High Court, I wasn't here when you asked the question. I understood that it was referred back to the regional court, if I'm correct.
The way it was, she applied for Rule 43, and then the husband or
wanted that to be varied.
Rule 43.6, which is a
Variation of that order.
And then now the court almost asked, why can't you entertain it in a different court? That's what I wanted down to, not in the High Court.
Okay, so yes, then I think my colleague has answered that question. That would, in my opinion, as well be in order to expedite such applications before court. due to the fact that the High Court, the matters currently being heard on the unopposed roll, as my learned colleague has stated, is taking quite a toll on our courts. The other courts, and as Ronel has stated earlier on, needs to get to a point to entertain matters in order for us to expedite matters faster, and that we not have too many matters pending before the High Court. So that would most probably be the reason why the High Court would have made such a ruling, referring it to either the Maintenance Court for variation or to the Regional Court where the matter can also be heard. That then brings me to the point of which orders can be varied, or High Court orders can be varied by our Maintenance Court. Section 6, subsection 1B of the Maintenance Act states that a maintenance order, whether it's made by a High Court or a High Court, can be varied in a Maintenance Court, whereby the court will look at whether or not there is good cause shown by the party bringing such a substantive application. Such an application will have to be brought before court by completing a Form B, which is your J107E, and then providing proof to that effect as to why such a variation should be considered by the Honorable Court. The person bringing the application will have to bear that onus and then show good cause. That is similar to what would have happened if it had to be heard in terms of Rule 43 subsection or Rule 43(6) in the High Court, where you had to show good reason for variation of such an order. So usually we try and see for matters to be referred to our lower courts in order for the matters to be dealt with more expeditiously, in order to bring the relief to the party seeking the relief in question in such matters which may be dragged out for some period of time. Furthermore, in the case of M versus M, the court also held that the grounds for variation or discharge of a maintenance order can be entertained on the basis of the aspect that I just mentioned, the issue of good cause in the lower courts. Section 8, subsection 1 of the Divorce Act of 1979 also states that a maintenance order may be varied if the court finds that there is sufficient reason therefore. And then the onus, as I said, of showing good cause rests on the party who seeks the variation. In Roos versus Roos, it was also held that a variation will be ordered not only in cases of breach by either party, but because there has been such a change in the conditions that existed when the order was made, and that it would now be unfair that the order should stand in its original form. So in general, the court will only order variation of an existing maintenance order where there has been change in conditions, considering whether the onus has been discharged by the party before the maintenance court. And as I've stated, that discretion is entirely in the hands of the court. Now, there are certain aspects which our courts incorporate in divorce orders, such as division of estates or the assets upon divorce. Sometimes parties will want to come to the maintenance court and want certain orders regarding that to be amended. Our maintenance courts do not have the jurisdiction to deal with aspects other than maintenance per se when it comes to amending divorce orders. Many people come to court and some of them want to complete a consent form whereby, for example, where one, say the respondent was in default and he wants now to settle the arrears. You will see, for example, where it states in a divorce order that the one party is going to get 50% of the house and the other party should get 50%. Now, because the arrears is so much for non-compliance or the aspect of the maintenance part of the order, you will see sometimes that some respondents now want to consent, okay, let her have the 50% of my share in respect of our estate that should have been dissolved upon divorce in order to settle the arrears. The maintenance court is a divorce court. So you need to understand that certain clauses needs to be varied by the High Court. In the event that such a consent is reached between the parties, such has to be brought before the High Court in order for that aspect to be varied. So that is one part with regards to that. With regards to access, contact, custody of the children, such orders can also be varied by our lower courts by bringing it, for example, before the Children's Court in respect of care and contact, and then the court can make an order in respect of that as well. But with respect to the maintenance part, any court, as Ronella stated, does have the jurisdiction in order to entertain the variation of such orders. So yeah, that's all that I can contribute. Thank you.
Thank you so much, Advocate Goliath. Does anyone have any questions for Advocate Goliath? Do we have online questions? Okay.
If the biological mother of the children is in the same household, but the main caregiver is the grandparents, because the mother's income doesn't cover all the needs. Can the grandparents take the biological father to court, to maintenance court?
Yes, in that respect, is this now in relation to a pending matter where the parties are upon? No, I mean, is your question? No, but in respect of the parties, are you saying that you're asking that the mother and father is getting divorced, or is this just a new case? Okay. Now, in that instance, if the grandparents or the grandmother is the primary caregiver of the minor children, then you would be able to have locus standi in order to approach the court and bring such an application before court.
Even if the mother's in the same household?
Even if the mother is in the same household, the court will take into account what the mother's contribution is towards the minor children in order to make a determination what the father of the children should be contributing in respect of maintenance for those minor children.
Thank you. Wonderful. Thank you so much, Advocate Goliath. Ladies and gentlemen, the moment we've all been waiting for. Our special guest, Ms. Shireen Rahud, is a sexual offences prosecutor based in the Wynberg Sexual Offences Court. And she recently did a sexual offences case. She led a witness in Northern Ireland and via an audio-visual link. So she's just going to take us through that whole process. How does she do it? Is it possible to testify from other parts of the world? And she'll also explain to us or try to give us an understanding of how NPA prosecutors protect women and children in maintenance courts. Ladies and gentlemen, let's welcome Ms. Shireen Rahud, please.
Good morning, ladies and gents. I am Shireen Rahud, and I'm presently prosecuting at Wynberg Regional G. I am here today to explain how I lead a witness in Northern Ireland. In a world that is currently experiencing harsh atrocities, we need to amplify the call to peace by liberating the stifled voices before they are completely silenced. And this bypasses the often nuanced context of mainstream media. We need to liberate the voices so they speak louder, yes, louder, but louder in a safe environment. We provide a platform of empowerment and confidentiality. So, in the applicable legislation that's important, you need to lead a witness in a foreign country. I refer to Section 158 of the Criminal Procedure Act, 51 of 1977, and also Section 51, capital C, subsection 1 of the Criminal and Related Matters Amendment Act 12 of 2021. So the proposed procedure was brought by myself after I consulted with a witness in Northern Ireland. Just a background into my matter, I received the docket in July of this year before the matter was set down for plea and trial. And it came to my attention that the complainant or the child witness had immigrated to Northern Ireland in the UK with her father. This was because her father got a job opportunity and she wanted to seek a better education for herself. I also noticed that there was a note on the docket which indicated that the complainant or the child witness wanted to proceed with the matter. She was not returning to the Republic of South Africa and she wanted to know whether she could testify via Zoom. I then I approached my senior, Ms. Naidu, in this regard for advice. My senior, Ms. Naidu, then contacted Advocate Africa from the local DPP's office for authorization. And she mentioned that Advocate Reuters from our local DPP's office has dealt with these type of cases via Section 158 of the Criminal Procedure Act 51 of 1977 and in civil matters, Section 51, capital C, subsection 1 of the Criminal and Related Matters Amendment Act 12 of 2021. I then contacted Advocate Dion Reuters to assist me to set up an audio-visual link to relay the testimony of the witness who was in the Northern Ireland in UK, and the matter was then set down for pen trial for the 18th of September 2023. Now I'll be explaining how I brought the application in court. So firstly, I placed the proceedings on record, the appearances on record, and then I put the 3 counts of sexual assault as well as 1 count of digital rape to accuse in my matter. The accused elected to plead not guilty. I then brought an application in terms of Section 153 of the Criminal Procedure Act that the evidence relating to a sexual offense be heard in camera, and that was Act 32 of 2007. I then informed the court that the state will be requesting the use of an audio-visual link to transmit the evidence of the witness who is not in court today. I explained that the witness is not in court today because she had immigrated to Northern Ireland. I also informed the court that the state is of the opinion that it will be in the administration of justice that the court allow the evidence of the witness to be recorded via Section 158 of the Criminal Procedure Act and Section 51, capital C, subsection 1 of the Criminal and Related Matters Amendment Act, Act number 12 of 2022. I then also informed the court that the state prepared for such evidence to be recorded via an audio reading, and that the state will set up a data projector and an audio-visual link to transmit the evidence of the witness who is not in court today. I also informed the court that the resources are available and will be clearly audible for the defense and the court to hear the evidence. And I informed the court that the state is of the opinion that it will be in the interest of justice to continue with the trial via an audio-visual link. Thereafter, the court inquired regarding infrastructure and whether it will be possible to relay the audio and the visual simultaneously with no lagging or interruptions. The court then also solicited the views of the defense on whether the defense agreed to an audio-visual link to lead the evidence. The defense in my case agreed. The court then gave judgment on Section 158 of the Criminal Procedure Act application and allowed me to set up the link after the accused obviously pleaded to the charges. I made contact with my child witness prior to bringing the application to ensure that all the equipment was working. After I established the link, the court swore the witness in and admonished the witness via Section 164 of the Criminal Procedure Act, and then the court requested the witness to move her or rotate her laptop camera to see if she was alone and whether she was not unduly influenced in this matter. I then proceeded to transmit the evidence of the child witness who was not in court today. Therefore, in a virtual age, it's mandatory to be more accountable with a wider interface audience reach and recognizing the ethical presentation of instantaneous acknowledgement of victims who often are marginalized and ostracized by the community. The virtual court can thus expedite the rule of freedom with urgency. Okay, I'll also be explaining the protective measures in family matters. So there is a service charter for victims of crime in South Africa. And that is basically your rights as victim of crime. And there's also service standards that are set in the service charter for victims of crime, which sets out the responsibilities that each government department must or should provide to victims when they present themselves at government institutions, public institutions, such as a police station, a court, and hospitals. So in the service charter, basically you have the right to offer information, you have the right to receive information, you have the right to be protected, to be assisted, the right to be compensated, and to be restituted. So basically, it sets out your right to receive, or the right to have privacy, and the right to be treated with fairness, and the right to have respect with regard to your dignity and your privacy. And also we do have protective measures in court where the rights of victims of crime in South Africa are protected. So basically all victims, all complainants and witnesses must be able to fully participate in court proceedings and have their voices heard, particularly in Section 153 of the Criminal Procedure Act 51 of 1977. Victims can testify in camera in certain circumstances, such as sexual offences. In terms of Section 158 of the Criminal Procedure Act, witnesses or complainants can testify via CCTV camera or an audio-visual link. And then we also have Section 170, capital A of the Criminal Procedure Act, where victims can testify via an intermediary in certain circumstances. So if the court does appoint an intermediary, thank you. If the court does appoint an intermediary, the state needs to prove, or the state can bring the application to use an intermediary if the witness is under the biological age or mental age of 8 years old, if that victim is suffering from a mental or emotional condition, or if the witness is an older person. In terms of Section 1 of the Older Persons Act, the witness or the victim can then testify through an intermediary. There's also leading case law with regard to protective measures in South Africa, and the leading cases is versus Lenting and others, the 2023 case, where the court held that our court system is based on the open justice system, which is constitutionally entrenched in Section 35, subsection 3, subsection C of the Constitution, which is that everyone has a right to a fair trial, which includes a right to a public trial. However, the court also held in that case that Section 153 of the Criminal Procedure Act expressly allows the court in exceptional circumstances to exclude the public from the court proceedings. And Section 158 of the Criminal Procedure Act, on the other hand, it allows witnesses to not testify directly in courtroom for a variety of reasons. Therefore, the court also held in this case that Section 153 of the Criminal Procedure Act is intended to protect vulnerable witnesses from public exposure. What I forgot to mention is in your application for Section 158, if you want your witness to testify via an CCTV camera, you need to prove, or you need to inform the court that it will not be prejudicial to the accused. It will be in the interest of justice. It will not prevent an unreasonable delay, and it will save cost and be convenient. So in conclusion, I would like to thank Advocate Reuters for creating this opportunity, and I look forward to many more life-saving moments like this. Thank you.
Okay, I just want to quickly intervene over here and say thank you to my colleague, Ms. Shireen Harwood, for being so brave and do what you did in this specific case. And most people don't know about it. And in some cases, cases are being withdrawn because the witness is not at court. And it can be that the witness is just scared of being in court, or in most cases that we saw at Weinberg, where a witness was killed a few weeks ago in front of court. And that could have been prevented if she was in witness protection and be allowed to testify via a remote link from wherever she was. Then that life would have been saved. So we've got this provision in section 158 that is available, and Ms. Harwood did put the guidelines. It must be convenient, it must be there must be infrastructure, and it must be able to be done by the courts. In most cases, courts will tell you, I'll get to you, Mr. Arendse. In most cases, courts will tell you that no, these infrastructure is not available, but most prosecutors have laptops and there is infrastructure in that sense. If you get 2 laptops, then you can do it. All you need to make sure is that you've got an internet link. And in most cases, if you can get your emails, then you'll be able to get an internet link and will be able to connect. Most prosecutors have MS Teams on their laptops. So it's possible. And the person don't need to be at a remote venue, can be that the person sit in a prosecutor's office and link is then created to the court. So in most cases, as soon as you ask that the audio-visual link be created, then there's the nuance or the thinking that no, we don't have an intermediary room, we don't have a sexual offences court, there we can't do it. It's not necessary. All you need to have is 2 laptops in 2 different venues, in the court manager's office and in another office, and you can create it. Or Belleville Court can create that link with UWC and have a venue available. It's easy and accessible if we know how to do it. But I would like to somehow encourage our other prosecutorial colleagues all over South Africa to do what Ms. Harwood did. If you need more information, please contact her. She's the expert in the field, and she will be able to give you all the information on how to deal with it. She is now the expert. And if you need more information, the 2 of us are willing to come and assist wherever in South Africa, and we need to get this up and running. It's in our law books for ages, more than, it's now for more than half a century, for 50 years, that's on our court book, the provision in section 158 of our Criminal Procedure Act. I just quickly want to just come back to, that is criminal cases, that section 158 is available. But what about maintenance cases? What about domestic violence cases? Is it possible to do that in those type of cases? Yes. In terms of our criminal law, Criminal Related Amendment Act 12 of 2021, and I want you to, if you have some time, have a look at it. The Criminal Law Related Matters Amendment Act 12 of 2021, we colloquially call it the GBV legislation, that was all promulgated last year by by Parliament and by the different departments involved in it. As part of the 3 GBV Acts, Act 12 was dealing with what I'm going to speak about now. Act 13 was the amendments to the Sexual Offences Act, and Act 14 was the amendments to the Domestic Violence Act. So those 3 pieces of legislation are called the 3 GBV Acts. Act 12 in section 51A makes a provision that intermediary can be appointed for any other than criminal matters, meaning the provision that Ms. Harwood used was in terms of section 170A of the Criminal Procedure Act. The equivalent of Section 170A of the Criminal Procedure Act, you find in Section 51A of the Criminal Law Related Amendment Act 12 of 2021, saying that you can appoint an intermediary for any other than criminal matters. Ms. Harwood could have appointed an intermediary in terms of Section 170A for a child that is under the age of 18. But in that specific case, because the audio-visual link was created and the child was in a safe environment where she felt safe, we decided to just let her sit in a room where she was on her own, and then in that way lead her evidence from Northern Ireland all the way to the Western Cape. That's what we did in that specific case. I dealt with cases where I led a witness in Panama that was 9-hour difference between South Africa and Simonstown, but we managed to do it, and it can be done. The authority for it, you find in the Criminal Law Amendment Act, Section 51C, capital C of the Amendment Act 12 of 2021. Please look at Section 51A for intermediaries and 51C for an audio-visual link. So what it means is, in a domestic violence matter, if you would like to, or your witness is scared of being in the same room as the person that perpetrated all the domestic violence act against her, and she's scared of that person, there's no reason why a domestic violence magistrate cannot lead the evidence of that, I'll get you, Tracy, of that person from another room. If she is safe in a place of safety where she is being kept, then why can't she stay at Sarki Hartman and lead her testimony from there? Or in a case where it is that she needs to be at court, why can't she sit on the 5th floor in the sexual offences court and a testimony be led to the domestic violence court that's on the 3rd floor? It can be done if it is practically possible. And if you've got 2 laptops from 2 prosecutors, then it can be easily relayed to the court where that person sits. So these provisions are in law and it can be used. It is just up to us knowing about it that you can apply for it. And most women go through a lot of anxiety before they have to testify and don't know what to do, because as soon as they're in front of the perpetrator that have been abusing them for all these years, then they just become so, what's the word I'm looking for? They can't speak and they become silent and they can't voice their opinion. And it can be interpreted by the courts that either she is lying or else that she don't know what she's talking about. And just because she's freezing at that moment in time, because she experienced all the abuse that you've been suffering. And there's a provision in law, Section 51C says an audio-visual link can be created with that specific lady sitting in another office at the same court, or sit at a place of safety, or sit in a hospital. Even if she's in a hospital bed, she can testify from there. And what better evidence won't you have in the case where the lady is testifying from a hospital bed, saying that the reason why I'm in this hospital bed is because of that perpetrator standing in court? Why do we have to withdraw cases that in that specific case can be dealt with either in terms of Section 158 of the Criminal Procedure Act or in terms of Section 51C of the Criminal Law and Related Amendment Act 12 of 2021. So these provisions are in law. It's just that we need to know that it is there, and they need to be the will of that specific court in order then to deal with it. In a case where a magistrate is going to refuse your application to have an intermediary there, or refuse your application to have an audio link, the magistrate, in terms of the Amendment Act, must give reasons on record and must state that applicant applied for an audio-visual link because she says in affidavit that she's scared of the person, and in this specific case, I refuse this link because we do not have the infrastructure or whatever the case might be. But the court must give reasons why. The court can't just say, nee, ons gaan nie dit doen nie. doesn't work like that. They need to give specific reasons why they are opposing it, why they are not allowing it. Lisa, I'll get to you. Okay, I'll first give Mr. Ashraf Arendse an opportunity. Otherwise, he's going to say that this is not a dialogue, it is monologue. So, Mr. Arendse, please come and stand here. I want our online people to also see who you are. And then I'll get to Tracy. Tracy, if you want, you can ask from there or you can come to the fore. Oh, Captain Arendse. Sorry, sir.
No problem.
Sorry, sir.
Good morning, guys. It's still morning, right? Thank you for your presentation. Well done. I think I just have a question to you and perhaps to everyone, right? In terms of section 170A, right? Making an application for the use of an intermediary, right, in special circumstances. My question is, why should that not be automatic especially when it comes to children having to testify in court? You can do, the competency test, that you can introduce the child to the court preparation office and preparing the child for court. And, you can say that the child is prepared and willing to testify. However, it is a different situation when a child is on stand and, not only just seeing the accused and all of these other different people, role players, but also being cross-examined by the defense. And I mean, it can be grueling. And, children, really, they just freeze, even if a child is competent to be able to testify. So my question is that in the interest of justice? Right? And I think that it should actually happen automatically where a child is, for argument's sake, under the age of 12 or something where they must, use an intermediary. Now, I've recently moved to the rural areas and, they don't have these infrastructure. And I don't think that it is fair towards, children for magistrate just to say that because we don't have the infrastructure, because we don't have an intermediary, therefore, we must expose this child to this, harmful situation. So yeah, that is just a general question. And I think, from the rural area, I'm going to try to advocate for that. And yeah.
Well then, I'll make sure that I get the title right now. That is Captain Ashraf Arendse, all the way from the Vredendal FCS in the west coast of the Western Cape. Thank you so much, Captain, for coming all the way from Vredendal to come and address us. The question is, why is it not automatic? The reason why it's not automatic is because of the provisions in section 168 of our 164 and 168 of our Criminal Procedure Act. Section 164 starts off with the oath or admonition. There are case law in the Western Cape where Judge Albert he said that you can't automatically assume that the child do not understand what it means to sworn in and understand the oath or admonition. There was a case in Malmesbury Court where a regional court magistrate just automatically went to the admonition and warned the child and said to the child that, listen, in that case, I'm warning you not to tell lies. In the case where you tell lies, you're going to get punished. The case went on automatic review to the High Court, and Judge Henny said that no, in that specific case, you need to start in terms of Section 164 with the oath, that is, swear to tell the truth, the whole truth, and by the truth, so help God. And if the child do not understand consequences of Section 164 oath, then you only move to the admonition. But the court needs to be convinced that the person do not understand the consequences and the purport of Section 164 oath. Because most of them are watching Judge Judy these days and they understand it better than most of us. Therefore, it is important that we start off with the oath, Section 164, and if the person do not understand, then you only move to the admonition. But in most of our cases, that's why what Mr. Arvood did is you need to have prior consultation with your witness. Once you know your witness, you will know whether the witness understand the spirit and purport of Section 164 and then move on to admonition. But we in the sexual offences courts, we will first do what we call court preparation. If we see the court preparation is of such a nature that the child only understands the admonition, then we will then ask the court to still do the oath first and then afterwards the admonition. But the child would have already been prepared that this is what's going to be asked, and she will know how to then be prepared to get to the admonition and be able to answer the admonition. That is just the procedure. There was a case in 2008 that was decided up north in Graskop, where a similar thing happened, where the Judge Eben Bertelsmann, he specifically said what you are saying, that why are we doing all of this? Why does we do it automatically? And he sent the case that he listened to the High Court in Gauteng, where, and then he also wanted to send it to the Constitutional Court, stating that children should automatically get that right to have the admonition being applied, and then afterwards the intermediary automatically be applied. But the Constitutional Court found that in that specific case, all of those cases need to comply with Section 153 open court, and all of those things need to be first be dealt with before we just automatically assume that the child do not understand those procedures. But it cannot just be automatically. The child needs to show to the court that they don't understand the spirit and purport of Section 164 before we get to the other procedure. But a good question, and maybe we can take it again to the courts, and specifically the amendment of the Sexual Offences Act. The Sexual Offences Act is amended or being reviewed every 5 years, so it can still be done to see whether it shouldn't be automatic right for children to protect their Section 28 constitutional vested rights. And I agree with you, the court or the Constitutional Court should specifically look at the Section 28 vested rights of children to protect it, even in cases of these type of cases in courts. Stunning question, Captain. I will make sure that I get the title right. Tracy, you want to ask your question? Okay. The case is pending. We're not finalized with the case. Yeah. Yeah.
For some that I found was ridiculous reasons.
Yeah.
So it's like the victim, when they actually gets anywhere with the court's laws, before that section of court's laws. I reiterate from Bongi's saying, you know, all of this and nothing happens.
Yeah.
When you read to the first floor and you have children, and you get, and you see the train that happens there, and you go down to the first floor, and you see the people sitting there, and not one of them is a protection order.
Yeah.
Not one person. The magistrate sometimes I think this is a woman.
Yeah.
You not hear what this other woman is saying.
Yeah.
So for me, it's like we sit here, but like in my family, that's just it's tricky because nothing happens.
Yeah.
So if you don't make a scene and meet Natalie, nothing happens.
Yeah.
So we got all of this stuff, and I just it's pending.
Yeah.
I've had a situation at our church where an offender was not supposed to be around children, was teaching children bad.
Yeah.
And nothing is done. Where they reported, nothing is done. We're still walking around, carrying on as if nothing happened. You go to court and in 1999, I mean, I sat there one day, not one female got a protection order. So
Yeah.
we like Bongi said, what is the point if we're not getting the protection? The moms aren't getting what they need.
Yeah.
But we're not getting what you're not getting what we need.
Mm.
So where does it end?
Yeah.
Where does it end? Where does it get better?
Okay. The question from Tracy sitting at the back is, what is the outcome of Ms. Harvard's case? It is a pending matter, and we would have finalized it if it wasn't for the attorney that got sick. But
It feels like there's never end. It's like the perpetrator always wins.
yeah, yeah,
I look at the university's colleges.
yeah,
The university rate is not our problem.
Yeah.
And the perpetrator leaves, he goes to college, the girl ends up broken.
Yeah.
And never gets fixed.
Yeah.
Universities are not interested.
Yeah.
They're not interested, so perpetrator carries on. You go to get protection order, what happens? Nothing.
Yeah.
Denied.
Yeah.
Denied. No, that person, the student has a right to education.
Yeah.
So for me, it's like this girl, I don't know what the situation is, but that's why I'm saying this, because I knew going to say they expect me or probably not sure. And
Yeah.
that's why I asked because I didn't expect a positive
Yeah.
outcome for the victim.
Yeah.
Because that's kind of like a thing. It's never positive, it feels like it's never positive outcome for the victim.
Yeah.
So we do all of this, like when we see this, like we carry on and we carry on. You don't have petrol to get your child to school. You can't go to school, so your child will go to school.
Yeah.
You can't feel safe because you can't get a protection order because denied. You go in there, literally 2 seconds, denied.
Yeah.
And then there's 1 or 2 people who go the extra mile. So I'm saying, when is it ever about the victim?
Yeah.
It's never about the victim. You put it on social media, look at that. Women for change. They need sued. They can't help other women. But they take legal fees because they need sued. How dare they talk about this guy?
Yeah.
How dare they talk about him? So they don't need sued for defamation.
Yeah.
And he walks around and he's on TV. Really?
Yeah.
So for it just feels like he's no. Yeah, the perpetrator always wins.
Yeah. Ms. Harris say that she finds that there is no recourse for victims. It's always the perpetrators that is the of a winner in the process, and that no matter what is being done, and she already knew it's going to be pending. But I hope that in this specific case, once Ms. would start with a cross-examination, there will no other way out for the perpetrator. Ms. Harwood will come back and report back on her trial once she's done, and then we will get a outcome in that specific matter that we can deal with. Liesel, you had a question?
I just want to ask, I see where it says that mothers can ask for intermediary. Who qualifies for as an intermediary? And then my second question is it only the victim that can ask for audio or in a separate room, or can the accused also ask because he's sitting in Durban, for instance, he hasn't got money to come down, can he ask for audio also?
Okay. Ms. Liesel Cornier's question is, who qualifies to be an intermediary, and is it only the victim that can ask to be to get a intermediary or to get a audio visual link? Number one, who qualify to be an intermediary? There's a list that is in the government gazette. I've got a copy of it that I can email to those of you that would like to get a copy of it. There's a list of people that pre-qualify to be intermediary. It's usually a retired teacher, a social worker, an educator that worked in the field of child development, or a pediatrician, but anyone that have worked in the field and understand how children react. All of them qualify to be an intermediary. And we usually take from a pool of retired teachers and retired social workers at the sexual offences courts to then be intermediaries. But these days, we also appoint social workers that have that count in working with children to be intermediaries. And there are more and more young people that is being used in the metro areas to be social workers. In the rural areas, we usually will ask people to put their names on a list, and then the regional magistrate can then choose, or the regional prosecutors can choose from a list of intermediaries who they want to use. When I was in Oudtshoorn in 1998, I used to use intermediaries that was chosen from a pool of intermediaries. That's 25 years ago. Captain, it shows how old I am. But that's the time that we use from a pool of intermediaries that were in the Oudtshoorn community that we choose anytime somebody will call Auntie Sina Boyson, are you available to come and help with intermediary services? If she is, then we will use her for that day. What happens in court is they have to come into court and they are being sworn in, and the court will ask certain questions to see expertise in the field in order to do it. The change now, Section 51C of the Criminal Law and Related Amendment Act, is the expertise are put on a file, and every time that they have to come and testify, they do not to go to all of that swearing in and having to answer 100 questions about their expertise. A certificate of competency will be on their file, and that will be attached to the J15 charge sheet. So they don't have to go through that whole process of having to establish their competency. That will be on the certificate of competency that will be attached to the J15 in order to deal with it in terms of Section 51A of the Criminal Law Amendment Act 12 of 2021. So that's the way we will deal with it going forward in those cases. Your second question, can an accused person also then apply to have an audiovisual link? No. Why? Because he was warned by court and he needs to be at court in terms of Section 152 of the Criminal Procedure Act. He must be in court, and that case must be in an open court. Therefore, he will not be able to sit in another area and then be able to testify from that area. That is in the case of criminal cases. In the case of civil cases, it's a different ball game. In terms of Section 51C, he can ask, if he's a respondent, he can ask that, listen, I can't get to the venue. Isn't it possible? I still want to participate and I still want the case to be finalized. Can't I sit in Pretoria and let my evidence be laid from there? In that case, it is possible that you can do it in terms of the Criminal Law Amendment Act 12 of 2021, where the respondent and his attorney is in another venue. The applicant can be at court or in another venue, and that's how you can deal with those cases. But an accused person do not have the right to apply for an audiovisual link or to be created or an intermediary to be appointed. In child justice legislation, we're going to change it in future, where in the case of a young offender can make use of the service of intermediary in the child justice related matters. Captain, I see you not, so I'm on the right track, so I'm happy. So are there any other questions? Sure. Yes. Okay. Do you want to answer, Ms.? Who prepared the child for court preparation?
Okay. So I prepared the child for the court preparation prior to the date of the trial. So because she was based in Northern Ireland, I had an iPhone, she had an iPhone, so I FaceTimed her at least on 3 occasions just to get to know her and to find out what the story was all about, what are the facts of the matter, and then I could decide whether I was going to use an intermediary or not. She was a brilliant witness. She was like intelligent, she was well spoken, she knew what to say, and therefore there was no need for me to use an intermediary in my case. Okay. The prosecutor, you get the prosecutor can prepare the child, or you get a court prep officer who's based at court to like just assess the situation. They talk to the child, they provide counseling if it's needed, refer them to social services or rape crimes, and so there is a platform for the witnesses to be prepared either at court with a court prep officer or with a social worker or the prosecutor prior to the trial date.
So does the child have to first go to court? Does the child have to go to physically to the court? You know, if the child doesn't want to be in the court surroundings, how does that happen?
So at the sexual offences court, we have like a witness room. So all the witnesses come for consultation at the witness room before the trial date. So in that room, we can already assess like who's going to deal with him, how we're going to deal with the matter, but it's better for them to first come to court so that we can assess the situation, whether they need counseling, whether they need to be prepared, you know, their state of mind, some victims, they actually break down, they freeze, they can't testify, and then we take a different route. Okay, thank you.
We have an exceptional person with us too, and that is Dr. Wendell Norkia, and he is a senior lecturer at UWC, and he also would like to quickly just address it.
Yes, thank you so much. I think also I was at court with my students 2-3 weeks ago at Parow Regional Court, at the Sexual Offenders Court. It's my first time ever I've been at the Sexual Offenders Court. And I would just want to add to the question that you have. There's a room, you actually mentioned the witness room. What makes it nice for children, well, nice, but appropriate for children, is it's child friendly. So there's pictures on the wall, there's dolls everywhere. It looks like a playroom. And that's what makes them comfortable. There was also a social worker who's stationed there permanently, who's very friendly, and we asked him a lot of questions, and he knows what to do in a situation. If it's a 3-year-old child, or 7-year-old child, 10-year-old child, or 15-year-old, they are very friendly, they are comfortable, and they even have dolls with private parts on the dolls. So during the testimony, they can show, where did the accused touch you? Where did your father touch you? So it was very touching to be there and to see what is happening. So they're really contributing to our justice system. It's excellent. Thanks.
That is Dr. Wendell Norkia. He is the senior lecturer in private law at the UWC, and criminal justice. Sorry, sir. Luckily, it's not captain. Otherwise, I would be in trouble. Dr. Norkia is in criminal justice and jurisprudence and procedure, criminal procedure, and criminal justice at UWC, University of the Western Cape. I already have an idea for our community dialogue, Dr. Nokia's observations of a sexual offences court. Dr. Nokia, will you be available the 25th of November to give us I always invite people on the spot, and that way they can't say no. So thank you, Dr. Nokia. You are on the program the 25th of November when we celebrate the 16 days of activism, and we will get Dr. Nokia giving his observations from the Parow Sexual Offences Court and what he saw there. I just want to say something else, and okay, let me. One thing that we need to learn is if the government's hand is up, then you must stand to one side. My wife also like to say something. I'll give over to my wife.
I'm just going to ask behind the camera.
No, please come and stand here.
Good morning. I just wanted to ask the prosecutors in the room. I had the opportunity to be in a room with a victim who was being prepared, or rather they were seeing whether the victim could lead her testimony in court. And for me, being trauma-informed, with a counseling background, it was one of the most horrific moments I've witnessed. I felt that the prosecutor wasn't trauma-informed. I felt that the prosecutor was desensitized to what the victim was presenting. And the victim actually said, and I got permission to quote this part, the victim actually said, "Why am I being treated as a perpetrator?" As she was being prepared to lead her testimony. So yeah, it was a horrific moment for me to witness. Don't even know what my question was, but I wanted to say that I just felt that, yeah,
I'm not sure that prosecutors are trauma informed, and that for me is a big concern and worry.
So the question is that are prosecutors trauma informed, or do they know how to deal with these type of cases? We in the National Prosecuting Authority have specialist prosecutors for sexual offences cases. We've got in the sexual offences courts specialized prosecutors that have been trained in dealing with these type of sexual offences matters. We've got a one-day course where we do what we call social context training, where we teach the prosecutor to be sensitive to the needs of that individual and how to then deal with that person during consultations and all of it. And that's why Ms. Harvard had to do the consultation prior to the case. If we feel that there is more court preparation that is needed, then we will assign the young witness or even adult witnesses to a court preparation officer that will then assist that person in order to prepare them to be more comfortable in the court, explain to them where the magistrate sits, where the attorney is, and what's going to happen in court. And at times we do need to ask serious questions to see whether that witness will be able to stand cross-examination and be able to see how the person relate to some of the questions, which might sound and look to the outside person as if we are insensitive, and it's not that we're insensitive. It's we need to know whether that person will be able to stand cross-examination. And I've dealt with it in cases that I've dealt with in the sexual offences courts, where I need to ask the pertinent questions to see how the person's going to react, and to be able to know when cross-examination is going to happen from the attorney, that I will be able to ask for an adjournment or give the witness a glass of water, or then be able to pick up on the body language of the person. And all that we do during our specialized training of our prosecutors, like my colleague over here. They go to intensive training to be ready in order to deal with those type of cases. And on the outside, for somebody looking in, it might look as if we are insensitive, but we try in most cases not to be in any way insensitive. It's just that we are trying to play devil's advocate and see how the person is going to then react. What we do afterwards, the debriefing session, is where we tell them why we asked those type of questions and why we react in a certain way. And it's not that we are trying to put them as an accused on the stand, but for us to prepare them for that vigorous cross-examination by the defense. And that's what we need to achieve. So it's not used that we prepare the person for their statement and then she fumbles during, or he fumbles during cross-examination. So we need to know as experts in the field how the person is going to react. And that's the reason why we do what we need to do in those cases. I might say there might be one or two prosecutors that don't do the debriefing that make it look as if we are insensitive, which is not supposed to be the case in all cases. Mr. Captain Arendse?
Just on that point, it's also very important to understand that, in the legal system, right, you don't normally look at the clinical side or the clinical assessment, the therapeutic side of the child or helping the child through that process. But you're basically assessing the situation. Because, for example, if I ask a question, when did daddy touch you, or whatever the case might be, I need to give a focus question on whatever the child basically says or presents. Yeah. Because once I say shame or I hear that, the child basically picks that.
Yes.
And it can either manipulate the situation, or anything can basically happen. So you try to basically use a poker face. So I think perhaps for next time, I can like the doctor. And
excellent.
About forensic social work and
yes.
things. And then I can also perhaps bring what they call the anatomical dolls.
Yes.
With just
excellent.
The
wow.
dolls basically just to explain, what these dolls are and what are they basically used for, and when to use these dolls.
Excellent.
So perhaps
25th of November. 25th of November, Captain R. Excellent. It is a date with Captain Orange. So we've got two people already on the program. Dr. Wendell Norton. The online viewers, on the 25th of November, we will celebrate 16 days of activism. Captain Ashraf Arense will be in the house, and he will explain how they prepare witnesses for case in the sexual offences courts. He'll even bring anatomical dolls to show what Dr. Norkia showed as far as the genitalia that is on these dolls in order to prepare the witness to testify. So thank you so much, Captain Ashraf Arense. Thank you, Dr. Norkia. We've got two people already on our program. And then we will then deal with it from there. Are there any other questions? Excellent. No more questions. Yes. If there's no more questions, then who's next? Liesel. Okay. Let's have a 15-minute break, and after 15 minutes, Ms. Liesel Kanye will address us.
Online viewers, are you going to play the video? Break, and we'll be back at 12:15. For our online viewers, we do have an amazing video from Georgia Ridgway from all the way from KZN. She is an incredible ambassador for the Help a Girl campaign. So we're just going to play that video for you while we wait to resume our program today. And as we all know, Help a Girl campaign is led by Abongile Kwaza, which is an incredible initiative to eradicate period poverty, as well as advocating for menstrual health to be recognized in South Africa as a human right. So we're going to just play that for our online audience. We will see each other at 12:15. Enjoy. We are back for session 2 of today's community dialogue, focusing on child maintenance. And just a reminder, this session is recorded and it will be available on YouTube, on our Facebook page, as well as our website, www.childmaintenance.org.za. Ladies and gentlemen, we are going to welcome our very own ambassador and one of the founding members of the NPA SOCA Community Dialogues, Ms. Liesl Cronier. She's actually going to address few matters. One is going to give us feedback. If you were here last month, she shared about applying for UIF. So she's going to give us feedback regarding that, whether that was successful or not. And she's also going to talk about the support group that we have for mothers, especially in the Western Cape. But also she's going to share a recent experience, actually a very traumatic experience, where her protection order was violated. And unfortunately, the police and the courts failed her. And so she's just going to take us through that and share her experience. So, ladies and gentlemen, let's give a warm hand of applause to Ms. Liesl Cronier, please.
Good afternoon, everyone. Thanks, Bongi, and thanks for the invitation to present this Saturday. I just want to give feedback. At the last presentation, I spoke about the different ways of getting arrears maintenance, and I'm basically following the rules of the Maintenance Act to the T. So the next step I had was to apply for a UIF because the person, the father, was dismissed. So I applied for his UIF. And that took a real long time because you've got the Department of Home Affairs and UIF involved in this matter, the court. So you have to stay on top of your game. You have to run and run with this case and run with your case on your own. Follow up every week, which I did. I got to a brick wall where there were no answers, and they told me the money, they're trying to pay the money out, they can't get through. And when I went to the maintenance officer at the court where I'm situated, she phoned the person at the Department of Home Affairs, and they were trying to pay the money into the defaulters account. So she quickly rectified and said, but did you not get the proof of the account that it's supposed to be paid in? Oh, yes, here it is. We'll quickly change it and we'll pay the money into the account. So the money was paid, I think, 3 days later. It was a relief. It was 3 months maintenance. But I'm in my 10th month of no maintenance. But all the arrears that has been added up from 2020 is starting at 113,000 Rand, which has put me under debt review. So all of you who've heard the presentations of the presenters today, courts are failing the mothers. Defaulters are getting away in this country with a lot of things, with tea parties that they are being invited to. So, end of the day, the UIF was paid out to me with a lot of struggle, but with a lot of teamwork also. Yeah. So, if you can assist your maintenance staff at the courts, or the people that you work with at court, if you can assist them, or I'm not saying make friends with them, just be helpful. Don't expect them to run with your case. Assist them, help them, give them information, follow up. Did they speak to this person? Did they go and see them? Because that's the quickest way of getting an answer, or if you're in their face the whole time, unfortunately. Because otherwise, I mean, they're sitting with so many cases in front of them, they forget, they lose information, they can't track everything all the time. So
that being the UIF situation. So case closed. To the next possibility, where I'm now suing the parental grandmother for maintenance. And that case is due in December. So I feel like almost like a guinea pig to see, can these acts actually work in the maintenance system? It's very traumatic. It is, you feel like sending someone else in your place, but you can't, because you are the real deal. You are fighting for your child and you will have to do it. There's no other choice. Coming back to support for mothers in maintenance courts, you will or might be aware of the WhatsApp group that was established quite a while ago when we started this dialogue in 2021 in Stellenbosch. We started with a few mothers, then it started growing. At one stage, we were over 300 mothers or people or members on the group. And there was no real security system of who these people are, what are they doing there. Some of them are quiet, are not active on the group. So we started vetting these people, asking questions, which court are you at? And for a mother to, or for a parent or person to be allowed on the group, must be an active case in one of the courts. It's a free support group. It's a closed group, so there are rules and regulations. Every time a person gets vetted and it is a real person with a real case, that person gets sent a set of information which explains what can you expect. What do you do if you don't get maintenance? What do you do if you don't have a maintenance order? And what we find is that these people don't read the information that is what's sent to them, being sent to them. They expect you to do everything for them. There's also, we also direct them to the WhatsApp, to the web at www.childmaintenance.org.za that was referred to by some of the previous speakers, and also the www.lunchandlearn.org.za, where actual cases are talked and explained, and what to do by legal people. So we find that the people don't go through this information. They just want to get into the car and drive. They don't have the license yet, but they want to drive. We don't allow any attorneys on this group because we find in the past that it's becoming a playground for them to source clients. Some people spy in this group. They take screenshots and send it off to the other party. And we also have strict rules on this group, which is posted in the rules section of this WhatsApp group. And we operate between 7 in the morning and 7 in the evening. Sometimes we get so excited and overwhelmed that we go on over the time and then quickly have to close the group. At the moment, the group is not active. We had to close it temporarily due to a security breach. And to avoid situations like this in the future, we'll close it until further notice just to resolve the matter. So if you're on the group, be very mindful of what you say, information that you share, because you don't know who's on group that might leak information. It's not that we're the FBI or some kind of intelligence group. We are a support group. Yeah. We're trying to help other people because of our experience. And then you get a nasty situation that happened like this, where the link is cut, people that need the help can't get the help now, so we are also being contacted personally on our WhatsApp numbers for help and assistance. But we will continue in the near future. If you want to download the link for this WhatsApp group, it's at the bottom of my presentation on the next page. There you'll see it right at the bottom. You can take it down or contact us and we'll give you the link. We've been talking about domestic violence and court matters by a lot of the presenters. So I'm just quickly going to go through my slide. In domestic violence matters, an applicant, so for instance, I've got a matter in court, I can take 2 supporters with into the domestic violence situation. I've been caught with domestic violence applications where I asked on the group, or someone else also asked on my behalf on the group, please can someone go with Liesl to court X? I basically needed people with me to sit outside the court, because if the accused turns up with the attorney or legal person, I've heard how they can communicate and rattle mother. They talk loudly. They will say, you see, here she is lying because she's saying that, so don't worry about that. And those things that you hear affect you, like you've heard from presenters. It rattles you. You can't close your ears. You can't go deaf for that period. You hear these things, you pick it up, you become, your whole body, your DNA, your blood, everything starts shaking. It's a traumatic experience. So luckily, I had people who supported me, and I felt at ease, I felt calm. The best advice I can give you is sit and chat about other things than court matters, laugh it off, talk about anything but court matters, but make sure that you have someone there with you that can also be a witness in case of the accused being or abusing or harassing you whilst you're sitting and waiting for your case to appear. Please note that according to section 10.4, no person whose presence is not necessary shall be present at the inquiry except with the permission of the maintenance court. So if you want to take in your sister or your brother, you need to ask the magistrate or the opposition if they are fine with it. In my case, I was told no, the person must go outside. Right now, maintenance courts and the magistrates can decide who is allowed in court and whom not, meaning no support person can accompany a mother in maintenance application process. And the reason for that, they say, attorneys say that it's due to the POPI Act. Luckily, they've got another act to save them. No one is allowed in court. But the Criminal and Related Matters Amendment Act that you've heard of from previous presenters, Act 12 of 2021, allow for mothers to ask that an intermediary, you know also now what an intermediary is and where you can get hold of an intermediary, can assist her in proceedings other than criminal matters. Please note that this section 10.4 is not applicable to section 31 criminal prosecutions of a defaulter as an accused. Section 152 Criminal Procedure Act, all criminal matters in open court. So it's open court. People are allowed in court. You can take in your support group, and I'm actually inviting all of you to come and be witness to my criminal case on the 1st of November, because you will get a very good understanding of what the struggles are that a mother goes through and how many hoops you've got to jump through to get someone convicted, because you're sitting with all the evidence and you can't go further because there's an obstruction in the system. The 3 GBV Acts were promulgated by Parliament, this is, you've also heard from the previous presenters, to protect vulnerable mothers. Yes, it looks very good on paper, but unfortunately it's not being implemented. The legal people in court are not up to date with new legislation. Mothers can ask for an intermediary, you've heard this as well, to assist her during the maintenance application, especially if there is a historic of domestic abuse, Section 51A of the Amendment Act 12 of 2021. If you have a protection order, and this is what I've now done as well, I've included this in all my applications. I've sent it with my criminal trial that is due on the 1st of November. I've sent it on, I attach it to all my applications so that the court, the court manager, the maintenance officer, the maintenance investigating officer, that all of those people who deal with your file is aware of the fact that there's a that there is a protection order. The Domestic Violence Amendment Act 14 of 2021 include a group of vulnerable women, which includes parents of a child in a domestic relationship, which means a relationship between a complainant and a respondent in any of the following ways. They are or were married to each other, including marriage according to any law, custom, or religion. Whether they are on the same sex or not, if they live or live together in a relationship in the nature of marriage, although they are not or were not married to each other, or are not able to be married to each other, or if they are parents of a child and you're not married or never married each other, or persons who have or had parental responsibility for that child, whether or not at the same time. They are family members related by consanguinity, affinity, or adoption. They are or were in an engagement, dating, or customary relationship, including an actual or perceived romantic, intimate, or sexual relationship of any duration. Or if they are persons in a close relationship that share a recently shared same residence. I just quickly want to go back to, we were talking about domestic violence and how wonderful it is to get a protection order. It is difficult to get a protection order. When I was in court, the people that were with me in court can testify, everyone that went before me were not granted a protection order, and my throat actually started closing up. I went and stood on the wrong spot. I was pointed out I shouldn't be standing there. I didn't know that. And I felt like a victim in that court, because the reason why I applied for the protect order, all those nasty details, the words I was being called, that was read out aloud in court by the magistrate. And she read it without blinking an eye, as if she read a story to a child. Luckily, I did get the protection order. So about a week ago, the protection order against the father of my minor child was violated. He used abusive, psychological, intimidating, manipulating language. He asked me if he could phone me that evening, and I said no, put something on paper, because I know if he phones me, he's going to know whatever evidence I want to present. Sometimes your phone doesn't record properly, so that's why I wanted it in writing. So 1 o'clock that morning, I got the email, and unfortunately, I'm nosy. I had to read it. I couldn't sleep after I read the email. It was a long email with a lot of accusations. He copied the whole of the court that we're at, actually hanging himself. I corrected all of his information that he sent through, like the reason why I couldn't phone and the reason why I can't come down for the trial on the 1st of November. And because I corrected him, he blew up and he started, the next 2 emails that was sent was abusive. It was manipulative. It was, I can't explain it to you, because when I opened that email at work that morning, I immediately went into a panic attack, because for months I've been stirring up this abuse for so long. If you can't see it, it doesn't matter. Yeah. It goes and sits in your brain, and if your brain is not functioning the way it's supposed to be, it can be your worst enemy. And also because, you know, we also help other people. Where do we go for assistance? Where do we go for help? Where does Advocate Reuters go? Where does Natalie go if Advocate John Ray, where does he go if it gets too much? Where does Bongi go when it gets too much? We have to go to professional people and pay them. So I got a panic attack, anxiety, which I've never had since I started working. I immediately, on our group, we've got excellent people who are assisting us on that WhatsApp group. I contacted a social worker and explained the situation and asked whether I could contact her. She said to me, I'm phoning in 5 minutes. I quickly went to the boardroom. She spoke to me. She told me where to focus, calm down, how to breathe. That didn't really work for me because it's not taking away the situation. I then sent an email to someone else saying, I've had enough. I can't go on with this abuse any longer. I'm busy cracking up. And the person told me, go and open a case at the police station. My colleagues took me to the doctor. The doctor sat me down. He said to me, Liesel, if you want me to write you a letter to court without me asking him or telling him what's going on, he said to me, I can see you're a good mother. And I still get emotional because of that, because no one in court will tell you that you're a good mother, you fight for your child. You have to go through all this drama. You've got to be the strong one. Well, the father or the other person can sit there and rock up there without any information while you are compiling your evidence, while you are sending all your information every month with arrears. You are doing everything that you can possibly do. You complain to the highest level, still nothing gets done. And sorry, my filters are off now. I've got no more. And I'm not going to apologize for crying, for being angry, because my child didn't ask to be there. Yeah. If I could, I would take child worth and I would say to the magistrate, this is case number 520/212. Yeah. This case and file number has got a name, it's got a surname, it's got a future, it's got a mind, it's got a soul. Yeah. And I'm not going to let anyone stand in his way of getting somewhere in life. I don't want him to follow the route that I'm following. I don't want him to be, I must be careful with my words now. I don't want him to be the example of the parent that has been he hasn't seen him in 5 years. I don't want him to be that parent to his children. I'm trying to show him how to be strong, but he's only 8 years old. He needs to be a child. He should not be involved in adult conversations and things like this. He should be protected. But at times, I feel like taking him with and telling the judge, now you tell him why I must wait another 3 months, why I've been waiting for 10 months. His birthday is next month. Please tell him why I can't have a party for him, why we can't celebrate his 9th birthday. Because the other person says, shame, why don't you have a job? Shame, what happened? Why is the situation like it is? I went to the court earlier this week, and I went to the maintenance investigating officer, and I said to him, here is the supervisor's name, here is the supervisor's contact number, there is the proof of misconduct, because information was sent to the father last year in June, July, that if he does not comply with the specifics of his job, that he will be dismissed. The maintenance investigating officer needs to get instruction from a maintenance officer or a prosecutor. He can't just pick up the phone and get information or do investigation. But since March, I've been giving everything on a platter to that court to prove misconduct. We're sitting in October. The trial date is 1 November. We're almost at the end of the year. So you can just imagine what's going to happen. I was told to go to the prosecutor and ask her, when am I going to have consultation with her? Because we need to know what her strategy or the strategy is, what route is she going to follow. I walked down the aisle, I saw her coming from the front. She was on her phone. When she saw me, she quickly went into another aisle so she could avoid me. When I went to her office, I saw her in the passage and I called her name. She quickly closed the door so that I had no access to her. I told the maintenance investigating officer, she's avoiding me. I don't know what to do anymore. After being, after sending, every week I'm sending an email asking, when can I have a consultation? This is not a tea party. This is actually a trial. We need to be prepared for this. I got an email day before yesterday saying, we can meet the day before the trial at 10 o'clock. So I hope that person has got everything on file for the trial date. But I feel complaining at this stage is getting me nowhere. Something has got to give. I'm not going to keep quiet anymore. I don't know what's going to happen on the 1st of November. I know he's going to rock up here and say he lost his job because he had to be here for the trial. And I know that if we are going to ask him where is your letter, he's going to say that he didn't get the letter because he had to be here in Cape Town. I know the mode operandi that he will take. It's not the first time that this is happening. It's happening every 2 years. And I'm drained. This is the first time that I'm physically drained. I feel like taking myself off the group. I'm actually glad that there is a bit of a breather for the group to be closed. I still want to help other parents, but at the moment I need to focus on my case. I need as much assistance as I can get because it's do or die. If I don't show up on the 1st, then it's going to be struck off the role. But if he doesn't show up, it's like, okay, let's find out why he wasn't here. The kind of attitude, and I'm tired of it. So, like I said, you're all welcome to join me on the 1st of November to watch the proceedings. But please, if you do get in these situations and you need assistance, reach out to people who's been through the situation. Reach out to the group. Reach out to the website. Reach out to the Lunch and Learn webinars. It's so valuable You can put yourself in that situation and you can learn from it. And you learn from other people. Maybe there's something on the group that's not relevant to you, but in 2 months' time, it's going to be relevant to you. Then you know exactly what to do. So maybe I'm the guinea pig that needs to go through all these things so that I can report back to you to say it does work. It states in the act that you can do X, Y, and Z. You can do it, and it does work. If you show proof, if you have no gray areas, if you don't have any loopholes. When I went to the police station to open up a protection order, because of the violation of the protection order, I sat, after I left the doctor's rooms, I sat there for 2 hours, and after I got up and asked, why is this taking so long? A captain came out and with a raised voice with about 15 other people also still waiting in the police station said to me, can you see that we are busy? There's only one person taking statements. And when I said to him, well, why don't you employ more people? He said to me, you go and speak to the government and you tell them to employ more people. Until then, please sit and be patient. Thank you. And he turned around and he walked out. I was more traumatized with that whole situation. Because what if it was a rape case? I took down the details. We've also had this on the group where you can report cases or if you're being treated like that at the police station. When I got home, I phoned that number. It's a WhatsApp number that you phone. There is a person on the other side of that number. They take down your statement. It was a very nice and accommodating officer that took down my details. So I will fire at that police station as well. I went back there yesterday after I spoke to one of the ladies who works there who used to be on our group. So thank goodness I still have a connection with her. She immediately took me to the victims unit violation corner. It's a building outside the police station, not in front where everyone can hear what happened to you. She took me aside and she took down my statement. I got an SMS last night of the case number. I got an SMS just now to say that someone has been appointed for the case. I don't know what's going to happen in the future, but we need to speak up. We can't keep quiet anymore. You can't ignore it. And I can understand why people don't want to report things because you need to be strong. You've got to get a thick skin to get through these matters and these abusive situations. And there's a lot of abuse in this country and in this world, and we need to stand together to overcome it. So good luck to all of you with cases. Don't give up. Your children need you. Thank you.
Thank you so much, Ms. Liesl Cronje. Does anyone have any questions? Ms. Cronje? Okay, yeah, Liesl?
Hi.
It's the very first slide.
The next one, sorry.
Sorry, first, second, yes, that one for that.
You said that all mothers must have a pending case in South African mentions courts. So is it not possible to join the group because maybe a person does not have a pending case or they want to go through that process? Does the group provide certain
Alarm bells go off if people tells me I want to join, but I don't have a pending case. I want, the alarm bells goes off because that group we need to protect because that group is the only place where a vulnerable person can explain their situation, and we understand. There are legal people on the group. There are social people on the group, social workers on the group. There are experienced mothers on the group. So we prefer that you have a case or that you are in the process of opening a case with paperwork that you're not familiar how to complete the information. So I'll be very wary if someone tells me I don't have a case yet. We've had situations where we found out that it was actually a lawyer who is trying to do a thesis on some kind of paperwork. And sorry, you're not going to infiltrate our system and use our mother's cases and names to do that. But I don't know if that answers your question. So we are wary of allowing people on the group who doesn't have cases. But because you can imagine that there are people who are thriving, and if they can just get a little bit of information against you, they will use it against you.
Okay, just a follow-up. Do you then have something separate on the side? Somebody who wants to start a business but is a bit afraid because of this, that, and the other reason, where they can get support from people who are going through it, who have been through it, mothers that have questions about it. Do you have something like that on the side? Because some mothers want to do it, but they have so many fears, either the father of the child is extremely powerful, or if they take the father to the court, they will get less money than what he is consistently sending. You know, situations like that.
I think there are a lot of mothers with the same situation. I think there are a lot of people who don't want to join the group because of those fears. I'm unfortunately not going to divulge the information on how to do it, because there are people also obviously listening into this session and who will find loopholes how to get into the system. You can always contact one of the admin people who can direct you to the relevant person, legal person, a social worker, if that is the case. But you will get directed in a way, or maybe to the lunch and learn webinars, or to a mediator, or whatever the case might be. So there are ways of dealing with it if you don't want to be active on the group.
Just to answer a question, there's a website on Facebook, child maintenance, and sometimes people post on the anonymous that they have all those questions. You know, and that's where something I will comment and say, okay, do X, Y, and Z.
Yeah.
But I think that is more the form, because, you know, I'm also, legal people are also concerned about touting. And I think there's a fear that you mentioned.
Yeah.
That they will come in for now, but it's more to get clients from.
Yeah.
So the Facebook one, and the Jean Opperman one, in terms of, sometimes people will put on there anonymous.
Yeah.
And then they will ask a question, and then we will just, you know, but also it's not a matter of giving legal advice. It's just to say, listen, look at X, Y, and Z, and go look for it. But yeah, the Facebook ones are quite close because, you know, of the confidentiality of it.
Yeah.
And the serious matters down there. So I would recommend, you know, if you think about it, you know, the Facebook child maintenance group, they make provision for that, and you can be anonymous. So it's a matter, I have, for example, people will ask, I have to go to court, or what can I expect? And then sometimes you lunch and learn what you are expecting.
Yeah.
What are the documents you need to take? What are your steps you're supposed to do? And then we just refer them to them. So they make more or less provision, but where see, so that's quite trauma and it's quite confidential. So that's the kind of thing that you always get. So I would say the Facebook page would more make provision for your questions.
Advocate John Ray, you had your hand up.
I just wanted to add on. What my colleague is saying, the two groups, lunch and learn by Eugene Opperman, and then the other one, child maintenance.
Yeah.
Child maintenance and closing in South Africa.
Yeah.
That's run by the case. She's another individual, establishment, post anonymous and question. But what I would advise guys is approach the maintenance officers are there in order to provide for these schools and to explain to you and to deal with those questions that you might have. The questions of, okay, this person is how full or whatever. A lot of people don't know how these processes work. Has people in government or are widely education or it's not being forced because most people in HR at the workplace don't speak the language of this. Because sometimes you speak individuals that are lawyers on the streets or you are really by the machine. That's why things don't work out. Speak the people that used to do the work. That's why they get paid, that's why they work in public office and they are public servants, they work, they work. Don't you
It's true what you say, but some of those officials are not like, yeah. Anyway. Lauren, you had your hand up?
I have a question. I just want to say something to you. I feel your pain. And I know what you're going through. I actually just wanted to read the quote. Maybe you can just read the quote. And I feel this is relevant in all moms that don't feel appreciated by other people. But at the end of the day, it's our children. Yeah. See us. I just want to
A child asked their dad, "What is a man?" The dad says, "A man is someone who's responsible and cares for their family." The child says, "I hope one day I can be a man just like my mom." Let's profound it.
True, very true. Thank you. And so are all of you. Any other questions?
Yeah, just where and when is your case? The 1st of November, but what time and which court?
I don't know what, can I share that information? It's at Bellville Court, Court G. I don't know what time it will happen. I think they normally take the protection orders first. I wasn't given a time. I was just told to be there at 9 o'clock. So it's Court G, Bellville. You're welcome. Leslie, you had your hand up?
Yes.
That make me cry even more.
Right. Yeah, Liesel,
I've got water retention.
Well, I want to say a few things. I don't have a question for you, but I just want to say a few things. I've known Liesel for about 3 years now. She was in our very, very first dialogue in Somerset West 3 years ago. And I remember the first day I met you, you were in a ball of tears. Not like today. But I have seen you grow over the last 3 years. You become such a strong mother hen for your son. Yeah. Also for many, 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 many mothers. Yeah. You know, Liesel, often I'm not on the group, but I hear stories go around. I know that Liesel will see a mom that has to go to court and she'll often contact that mom and say, I'm going to take time off work to come sit and support you in court. So just now you said you're a bit exhausted. You want to take time off, and that's okay. It's okay to take time off. Yeah. And it's important. Because when we pour from an empty cup, we don't do any good. And so I think now as you focus on your case and you bring the justice you desire for your son, you need that time off. Yeah. But I also want to say, I know Bongi said earlier, we have these dialogues, and Tracy said earlier, we have these dialogues, but where are we heading? And I just want to echo what Judge Talari said a while ago, that maybe, and I do believe, we are the generation that needs to transcend the pain we are feeling for our children and for the next generation. And so for everyone in the room, everyone online, we need to transcend, take it as our mandate to transcend that pain. So that, like Liesel said, her son is not going to be that absent father for his children one day, but rather be a present father for his children. And about 2 weeks ago, Jen and I watched a documentary by Tracy Young. And the documentary was She Said What? What She Said. And it spoke about her journey in the domestic violence court. And what she said was, it took a long time. I think she was in court for about 3 years. She said if she knew what it was going to take from her and how the system was going to treat her, she would never have gone in the first place. But she's chosen to share her story because in the power of sharing our stories, like you have done, and everybody else is sharing their stories, bringing awareness to a system that is not holding the place it should, but also to change the narrative that families are holding in society. And after that documentary, one of them, a mom stood up and she said something very profound. She said, the men we are seeing today that are not paying maintenance, that are not putting fathers, are men that were brought up by single moms. What have we done wrong? And I think for me, what that meant was, if we do not change, we're going to see the generational pattern again. By creating the awareness, we are going to change those patterns. And that's why we have these dialogues. It's important. We might not see the change with your case and Bongi's case. In my case, I never saw it. But that's okay. We're transcending that pain. We're setting a new narrative. We're having Ms. Rawat coming to share how she was able to do something different in the court. We have Advocate Goliath. I've worked with him, an amazing maintenance officer, setting a new precedence in the Deep South. In 2 courts, not 1 court, 2 courts.
Yeah.
We need these conversations. Where people rise up and say, I'm going to burn the candle in my corner. And the more we all do it, Liesel in Belleville in her little corner on WhatsApp, Bongi here on this platform, Ms. Rawat in her different, she's moved from court to court as they need her. If we all light our little candle, in 10 years, 15, 20 years from now, we're going to see a different narrative in our justice system. But as a mediator, I don't always say the law is not there to enforce things for us. We need to change the narrative in our families. Change begins with us, within our families. And when we change our families and our families are whole, our communities will be wholer. So that is our mandate. That is why we're having these dialogues. So that was my comment to you, Liesel. Keep going.
I'll never give up.
And you're such a good mom. I mean, there's many times Liesel has not pitched for a meeting because she has to bath her son, do homework, and cricket on a Saturday. We're very proud of you, and he appreciates you. Well done.
Thank you.
Yeah, thank you so much, Ms. Liesel Cronje, and thank you so much, Natalie Reuters. I always get so triggered, so just forgive me. I am a very emotional MC, because for us, this is not just a dialogue. This is our reality. We're not just here to debate. This is our reality. Liesel said the case numbers have names, souls, needs. The case numbers are the future of this nation. So maybe if we can just take a moment and just let that drop, because sometimes we just think it's paperwork, it's files, it's humans, it's children. It's women like us. I'm not gonna lie, I am tired. I have nothing more in me to give. I'm tired of fighting. I have no strength. Do you still have a why in you as you sit in this auditorium or watching online? What is your why? I would love to keep on pushing, but I'm struggling with that why. Why am I still pushing? Yes, I know. I'm looking at the future. But between now and time, there are basic needs. So, if you are here, take my hand and remind me of my why, because I am struggling. I know I'm fighting for the future of this nation, the future of the children of this nation. But between today and then, there's still a process in between, and I am struggling. Am I the only one? Am I the only one? I know that I have that mandate, and it's very clear. That generational mandate, very clear. But it's the in-between. If you still have a why and strength in you, take my hand today. Take the hand of the person next to you and encourage them to push. On that note, again, I just want to say thank you, Advocate Goliath, for what you are doing for the children and the mothers in Simonstown. May South Africa see more and more of people like you who still carry that true heart for justice. Like now you just said, oh, just go to the maintenance court, because for you, it's normal. Providing an efficient service is your normal. You're like, just go to court, because that's just who you are. That's what you release. For you, that's your everyday life. But as you know, we experience differently from other practitioners. So prayer as a mother is that South Africa would see more and more of maintenance officers, of advocates like you. So thank you so much for serving your community so well. Okay, so let's welcome Advocate Goliath. He's going to be talking about high court divorce orders and how they. Are you done? Oh, sorry. No one told me. Okay. So we're going to welcome Advocate Dion Reuters. Ladies and gentlemen, let's welcome Advocate Reuters.
Advocate Goliath condensed all of it in one when he had his opportunity to speak. So thank you so much, Advocate Goliath, for that presentation. I want to end off today's session with our last talk. We had some UWC law students that were sitting here in front. And one of the students asked me that, wow, if this is the narrative out there, then what am I going to be doing, or what am I going to be presenting as a legal person in the legal fraternity out there, where I, at the end of the day, go into the family courts, and what am I there going to present there if the reality is so real that women have to struggle the way they are struggling? And I said, no, it doesn't need to be like that. If you apply the law properly, Advocate Goliath will also say the same as what I'm going to be saying now, as well as Dr. Nokia. If the law is applied properly, then the legal fraternity will be able to do what they're supposed to do and not just let cases be remanded and remanded. So How do you do that? You start off with Section 10.6. Section 10.6 of the Maintenance Act says that these cases should not be prolonged and be remanded and are remanded, and that the postponement should be limited in duration and number. That's where it starts for the legal fraternity. So my advice to the attorneys out there is, do not let a case be prolonged where your client comes to you a day before the matter is supposed to be heard and you're going to court in order to just get a remand, because that is in confliction or contradictory to Section 10.6 of the Maintenance Act that says postponement should be limited in the number and duration of postponement. So attorneys can help the mothers and law process by not letting a case just be remanded unnecessarily, unless in that specific case there are good enough reasons. But then at least Section 10.6 says if the case should be then postponed, then you need to then at least come with an offer in the form of an interim maintenance order. That's what Section 10.6 further says. So if the case is going to be postponed, then at least make an interim order. So when attorneys come to court after getting a brief from their clients, they should at least come with an interim order to that court that they are bringing to the table, except for asking for a remand. But these days, attorneys are getting a bad name. Attorneys are, at the end of the day, making the legal profession the way it is, where students will feel that I don't want to be part of it. If students do not want to be part of it, then they will do as what I am trying to recommend now. Section 10.6, limit your number of postponements. Section 10.6, bring an offer to the table in the form of an interim maintenance order. Once that is done, then you facilitate the process for women to at least then get some type of recourse in the maintenance system. Section 51C, if you know that there's an interim or some type of a domestic violence order in place, Section 51C of the Act says audio-visual link can be created. Do not unnecessarily oppose it. If you know there's an interim order, that's the first question that the attorney should ask his client. Is there interim domestic violence order in place, or is there a final order in place? And then make it a suggestion that the two parties don't sit in the same room. Don't badger your client's ex-wife or ex-girlfriend, but somehow facilitate the process. The case that we dealt with, Ms. Harwood and I dealt with in the Weinberg court, Mr. Parker, the attorney, and I want to mention his name, I know I'm not supposed, but Mr. Parker in that specific case, before he started his cross-examination, he explained to the young girl why he's asking certain questions, and he's not asking certain questions because he is, as the attorney is asking it, but that is the instruction that he got from his client, and therefore he have to relay those questions. But he did it in such a euphemistic, beautiful way that the child didn't feel threatened, or the child didn't feel as if she was being seen or being criticized as if she did something wrong. And that's what attorneys are supposed to do, is to make it more acceptable. They can ask the questions and at the end of the day expose credibility or expose that this child is not telling the truth or whatever the case might be, but in a euphemistic way where that child still have their dignity, where that woman still have their dignity. Cross-examination shouldn't be where a person is just going to use the criminal justice process in order to badger and be seen as a ruthless attorney. That's not what it's supposed to be. Attorneys are judicial officers that at the end of the day bring the truth to the court, and that's all that they're supposed to do. So if the attorneys out there would like to somehow assist the court, not even the mother or the opposing parties, to assist the court in getting to a just and equitable order in terms of Section 15 of the Maintenance Act and get to a pro rata contribution, then make known what is the means of their client And the sooner they do that, the quicker we can get to some resolute or some type of a order in place for that person, and not where the woman leave the court every time feeling that she is being let down by the system. Liesel's last slide, can you just get to that last slide? Women feel depressed and leave the court always in a sense of depression or complaining that they've not been heard. Now, I specifically asked Liesel to include this slide because a lot of women out there usually end up crying when they leave the course. For those women, I just want to say that this say or that Olik Vijik, I know I'm not pronouncing the surname correct. He says in one of his videos, and the YouTube link to his video is over there, where he says, tears clean the windows to your soul. And it's so true that you might be going through a difficult time, you might be struggling, but there's always hope for you. And Nick, without hands and arms, nothing. And he still say, even if he fails 100 times, he'll still go ahead and still go on fighting. Same way Liesel is still fighting. How many times I've stopped counting how many times Liesel have been in court over the last 2 years that I've been with Liesel and have seen the struggles that she's gone through. Then she still have the vigor after 2 years to still say, Mitchell's Plain, I'm coming to Mitchell's Plain, I'm going to go and help women there. She got a group with another, except for the 300, there's another Mitchell's Plain WhatsApp group with more hundreds of people that lady on her own in the evenings answer questions. I haven't been for a while now, and she's been answering those questions on her own, despite all the challenges that she experienced. Despite having to show to the courts that actually UIF can be deducted for maintenance arrears, because some maintenance officers all over South Africa do not know it, and Ms. Liesel Kanye had to somehow show that to the courts. And that's what it's all about, is that we need to somehow have these type of activists out there, not just activists that criticize the system and say the system is not working, but actually going into the dysfunctional system and make it work for them the way Ms. Kanye makes it work for her. And that is what it's all about, is that if all of us come together and show, but actually there's a section 158 that says that women can get or vulnerable groups or vulnerable children can get an audio-visual link so that their testimony can be relayed, and that's what we should do. And attorneys should lead by example and say that, well, if the prosecution would like to do a audio-visual link, why not? Let's have this audio-visual link. And it's important that we get these type of messages out there. So what I would like to encourage people is go in the different groups, WW Child Maintenance. You'll find a lot of information on how to do certain things in the family court systems, not just maintenance court, also domestic violence and the children's court. A lot of affidavits, a lot of information on there. Mr. Eugene Opperman, I have a group, Lunch and Learn, where every Wednesday you will give information pertaining to how you can deal with the maintenance court and with the different courts. Thank you, Chaplain, for your presence today. And all of these places where we can source information. The Facebook groups, Child Maintenance Difficulties in South Africa, there's another group where you can source information in order to get help, in order to take it further. But it starts with attorneys also bringing their part, because the piece of legislation is the way it is, but sometimes there are those attorneys that give the profession a bad name. And those are the ones that we need to root out in order to make sure that the profession stay proper the way it is. In my handout, you'll find on page 2 and 3 information on maintenance. And it gives you a whole lot of information about how you can get lying in expenses, to calculate it in the case where you don't have a court order, how to deal with maintenance officers that are not doing what they're supposed to do. Then you can file a complaint at servicedelivery@justice.gov.za, Or if it's a prosecutor that's not assisting you, that you can then go to the NPA and file a complaint against that prosecutor that is not assisting you with your case. If it is somewhere out of the Western Cape, then you can file your complaint at communications@npa.gov.za. If it is in the Western Cape, you can send it to communications@npa.gov.za, and you can CC it to C Clark, that is CCLERK, C Clark @npa.gov.za. If a prosecutor in the Western Cape is not assisting or is not helping you or is rude to you or in any way makes you feel humiliated, then file a complaint at the NPA and we will deal with that person. If it's a magistrate that is rude to you, then you file a complaint at the Magistrates Commission. I saw the Magistrates Commission, so website is updated. So if any magistrate is in any way rude to you, where she tells you or he tells you, yeah, but give the children to the man, he can take better care of the children, you file a case because it's humiliating, it's degrading against that woman. No magistrate should ever speak in any way towards a woman to make her feel degraded or less of a woman or less of a mother because of what she's doing. The person at the Magistrates Commission's name is there, but you just send a on the Magistrates Commission, you can send a complaint on the website itself. There's a tab where you can file your complaint if it's against the magistrate. If you need an update, we will do it at our next community dialogue, which is the 25th of November, where we will have all of those details of the people that you can complain to in case you need to complain against a maintenance officer, a public prosecutor, or against a magistrate. If it's an attorney, then you can file a complaint at the Legal Practice Council, the LPC. On the LPC website, there's also a portal for complaints where you can file a complaint against such a person. So what I'm planning to do is for the 25th of November and the 9th of December, I will give some type of handy hints or some tips for attorneys and people in the legal profession, in the family courts, to deal with what I propose or what we propose is a better way of ensuring that women or children get a better deal. Because it's no use our constitution say best interest of a child, section 7 and section 9 of the Children's Act says best interest of the child, but women don't see it when they get to court. Women don't see it when children don't see it when their mothers return and they ask, mommy, what happened at court? And the mother, they find the mother sitting and crying, children's perception of the justice system becomes negative because of what they see. There's no use. We've got a section 28(1)(h) of the Constitution that says that whenever any rights of a child is infringed, that person's got a right to legal representation. But then the legal aid board is going to say that no, there is no legal representation unless the respondent have a legal representative available. It doesn't say in 21(h), please. Just one homework. Look at section 21(h). I want us to discuss it 25th of November because it's unconstitutional what is happening currently, that mothers have to fight for their children on their own. Section 21(h) of the Constitution Act 108 of 1996 says that children have a right to legal representation. Mothers don't go to court because they enjoy going to court or getting up in the morning going, oh, how can I make my day nice? Now I'm going to court. The court is not a nice experience for any woman in the world. So why will a woman ever want to go to court? Is because they see court as their last resort and they put their faith in the justice system. And if the justice system is not working for women, then we need to deal with it. Unconstitutional if section 21(h) says that mothers can get a right to legal representation, but when they stand in court, respondent comes to court with an attorney, then they will have to first give a good reason why they should get legal representation. And if they earn more than $250,000 house, just a house, then they do not qualify for legal aid. but then the attorney, the father or the respondent is allowed legal representation, but the woman is not. That's contradictory to Section 21H. And we need to somehow deal with it. Whether we deal with it in the Maintenance Amendment Act or in the Justice Portfolio Committee, we need to start dealing with it, because I can't see why women have to struggle like this in South Africa on their own. And if that's the case, then the NPA get to the table, because then the NPA should be the legal representative of that woman. But we will say in most cases, we only represent the best interest of the child, so the mother stand on her own. That's why Section 11(1) of the Maintenance Act is the way it is, without a provision in Regulation 5. Section 11(1) deals with subsistence and travel allowance. It says that any woman or any person can apply for subsistence and travel allowance. But when women go and apply for a taxi fare, getting there, or for the lost wage because they stayed out of work, then the magistrates as well as the maintenance courts will tell them Regulation 5 do not provide for them. Therefore, they are not entitled to legal representation. That's not right. So these type of things in the maintenance legislation, we need to discuss and somehow find common ground. And our attorney, Jonathan, and the rest over here, we need to take this to Parliament and deal with it in Parliament and say, but Section 11(1) and Regulation 5 do not speak to one another. And this is what the community dialogue is all about, is to make sure that we inform women of what is happening and what the legislation says and how are we going to make it better. And that's what we will be dealing with over the next 2 months, that we will be having these dialogues. So I'm going to hand over to my colleague so that she can say what is in store for our 25th November community dialogue, and I will add a little bit more. But we already have two people on the program. Dr. Wendell Norkier, the senior lecturer at UWC, will be in the house, as well as Captain Ashraf Arnser will be in the house, and we will see if we can lure Advocate John Goliath again to the house and then have a fruitful conversation on the 25th of November. But my colleague will give all of that information.
Okay. And I'm giving out your email address. Thank you so much, Advocate Generators. So as we all know, on the 25th of November, we are starting the 16 days of activism against women, against violence against women and children. So Advocate Generators has extended an invitation to the members of the public. So if you're here or watching online, to submit their stories or their experiences with the justice system. So you can just share your story, or if you have any recommendations or solutions to, or you have an experience or you've won a case, we would love to also hear those stories, please. We desperately need to just, we need hope. So if you have any story of a success in the justice system, or you just want to share your experience with the justice system, please send your stories to Advocate Raters' email address is draters, so DRUITERS@npa.gov.za. So if you can just submit your stories, or if you have any solutions or recommendations to Advocate Generators, that will be amazing. And obviously, we are so honored that Dr. Nadia and Captain Arnser will be gracing the stage, one of the keynote speakers next month. So we really are excited, looking forward to that. We are going to send out a link. So maybe first week of November, we're going to try and send out the link for you to register on Quicket. And then obviously we will conclude 2023 dialogues on the 9th of December, and that's also going to be an exciting dialogue. Generators, do you have anything to share before I close? Okay. So this is it for today. My name is Bongelwa Andash, and it's been such an honor to host you today for today's dialogue. let's enjoy the rugby match tonight. If Mr. Den Holland was here, I was actually going to sing Igwijo with him, but I don't know if anyone else knows any of Igwijo. I would love to do that, but let's enjoy and let the game tonight and support the Springboks. I have no doubt we are bringing the cup back home. All right, thank you so much. Enjoy the rest of your afternoon.